Okay, well, good morning, everyone, and welcome to day 15, which is the final day of the Viva Supplementary EES hearings. Today we'll be hearing finance reply submission. Are we waiting for anyone else? Yes. Sorry, and we did start half a minute early, so but all we did so far is to say hello and welcome to everyone. Just to let everyone know that this morning we received the school's response to the IAC's questions on notice, which have been given document number 143. Is there anything in particular you wanted to address us on about that?
No, it's in writing and I wouldn't do anything except read it out. So if you've had the chance to look at it, unless you had any questions, I'd just tender that.
Yes, thank you. We also received the EPA's response to the questions that we put to the EPA when they were giving their submissions. We've received various speaking notes from parties who presented last week, including the EPA, and they're all now in the table documents folder in the Google Drive. That was it in terms of preliminary issues from the committee. Is there anything for the proponent to raise as a preliminary issue?
No, only that we understood that because that document was filed this morning by Mr. Finanzio, you might want him to show you what that document was before we commence this point. Did you say that? We're not doing that.
We did.
No,
So I'm not just late, I'm late to the party as well.
We're taking that as read. We've had a brief skim on it because we haven't read it in detail.
Sorry.
But nothing more to say about that.
No.
That's good. All right. So, Mr. Townsend, we're ready when you are. We've got your closing submission, which I think is document 142. So we'll hand over to you to take us through that.
Thank you. Well, hopefully I've caught up. And good morning, and thank you for being back here on the Monday. You travelled safely. And what we're going to do this morning is take you to our reply submissions, but unless things take longer than we think, we're wondering whether we can see how we go, but whether it might be a situation where you might want a small tea break or something, but that we push on rather than make everybody wait longer.
Yep.
So we are going to be a little bit succinct where we can, rather than keep you such that you'd have to take a full lunch break. But let's see how we go, and we can do it. But that's the plan. The next thing is to take you to the document, which I assume has been given a document number by now, but our reply submission.
Yep, 142.
Thank you. And may I just ask, oh no, that's all right. So document 142 is a written reply. And as with our closing submission and other days, it's my task to open the reply and take you to some what I might call process matters. And then it'll be Mr. Chessel taking you to the evidence matters on noise and, of course, marine impacts. And also Mr. Chessel will address you on the structure of permissions, if you like, and conditions as they affect, particularly the submissions on noise. You'll see the way we've structured the written submission is to provide a written submission that within the main document includes some introductory comments and responses on the process issues. I mean, what we've called a focus reply in C, we've singled out the agencies in particular, but submissions by some of those groups that included more detail in specific matters. And we've attached as an appendix a full response that includes, as a courtesy, a response to each of the submitters. We wanted to stress this morning that it's not in doing so that we put one of the group submitters at some higher level. They're all equally important. There is no submitter here that is more important than the other submitter. It's only that it just seemed to us to organise the report that we had to provide more paragraphs, as it were, and more direct responses to some of those other submitters. And so it's with that as a segue, if you like. You'll see that one of those submitters we did deal with, obviously, was the Geelong Grammar School, which provided its closing submission as recently as Friday. So we've probably gone a little further in some of the responses to that because that was really, in some cases, the first time some of those matters were raised. And so we've given a little bit more attention to that for you in this document, but again, without in any way wanting to convey to others that they're less important, and they're not. But it's a useful segue for me to start without going to the written introduction at this point of the written submission. In a sense, it's convenient because I'm dealing with process to start with a position as advanced on Friday by the school, but I'm minded in a sense to my childhood when Westerns were fashionable and spaghetti Westerns were really fashionable, and there were gangsters in the room, and the whiskey was out and the cards were getting played, and all those one-liners, sound bites that came out of those films. And one of them that I recall from a young age is never play poker with a man who calls himself Honest Jack. And of course, the message is if someone's being honest, I have to tell you that. I'm not saying that anyone's not being honest. Don't get me wrong, it's just for the metaphor. But in this context, I had a look at the Geelong submission and paragraph 3. The school's position is straightforward. And I invite the committee in reflecting on this to judge for itself whether what was then set out for you was a straightforward submission, particularly on matters of process, or whether that's a matter you might judge for yourself. But can I commend the committee to a straightforward interpretation of the task? On that we can agree. Whether what follows up to between about paragraph 30 and I think something like 120 odd, whether that's a straightforward interpretation or a straightforward case is, I'd suggest to you, somewhat doubtful, let alone whether if you can go to paragraph 33 as an example and paragraph 34, whether at paragraph 33, which I'll come back to, which purports to advance what apparently Viva said the scope of the inquiry is, which is not correct, what they say we said, to then say at paragraph 34, the premise is simply wrong on a proper reading of the document. And can I say on the simply wrong, we again invite the committee to have a proper reading of the document, but we suggest that you might find that the proper reading and the logical reading of the task before you is one that supports the way we put the whole case, the whole way the SES was put, and that it might be in these 100 paragraphs that the message is somewhat blurred, not in the preparation of the SES or a fair reading of the Minister's directions. But I thought the best way to do it, instead of sort of some kind of counter attack, is just, albeit on the last day of the hearing, to screen share the document that is the Minister's directions. And just to say a couple of things about this document that might assist the committee, hopefully, from removing the debate away from cryptic legalese to reading the document on its face value and for the purpose it serves. And that's probably the first point that's worth making here. The document on its face in paragraph 1 points you to the only relevant statutory provision, the key one, section 5 of the Environment Effects Act. As it was put the other day, it doesn't define additional information, I think was the comment, but when you go and look at section 5, simply as it's written, the meaning of that provision is very sufficiently conveyed internally because it says any additional information that he or she considers necessary, the Minister. I wouldn't have thought it suffered from a lack of needing a definition, it's a supplementary statement, additional information that the Minister asked for. That's all it says. And the next thing to say about this document is therefore what you have on the face of this document is not the Australian Constitution, it's not a statute even, it's a set of instructions. A set of instructions written by the Minister for officers at DTP, for the proponent, for you, for the Minister to try to explain what they want. It doesn't suffer some kind of interpretive gymnastics to read a list of instructions. It's intended to be used by ordinary people reading the document to get the job done. And so it is, we'd say it's very clearly written and very logically written and very logically set out, just to ask people to go and do a job. And so the kind of, well, you must have regard to this, you can't have regard to that, really just loses its way, because it's not even responding not only to this document, but it's not responding to how we've prepared the SES or put our case. And it seems to be, if I'm right, that the gymnastics is meant to leave you feeling that something wasn't done or hasn't been done satisfactorily, or that we're trying to shut out some piece of information, none of which are true. So if you go to this document, it points out, it uses the expression directions. It didn't have to. That's how the minister's chosen a useful term to convey the instructions or what the minister wants. It says in the second paragraph, the document sets out the minister's directions for the preparation of the Viva Energy Gas Terminal Project Supplementary EES. So you're under no doubt that this is the document that contains the request, that it asks for further investigation to be documented in the Supplementary EES, and it goes on. I won't read you back through your purpose, but it's the first point that refers in a predictive sense to your appointment, because it's going to wait the report of an inquiry to be appointed at that point in relation to the Supplementary EES. And then you get to the objectives, and importantly, and one point that is really the fallacy in the argument that's against us, is that the first bullet point, on the one hand, points out the 4 relevant environmental matters, which you're perfectly clear on, but then says that even in respect of those 4, it's especially with respect to the consolidated recommendations for further work. And you'll notice they're called there consolidated recommendations for further work. That's very straightforward language, and it is those consolidated recommendations. So there is important to separate the two, the 4 relevant matters and the specific tasks you're asked to do for the SES. They're 2 different things. It doesn't mean that if something's not done in a task, it's not a relevant matter, but it's not fair to say you should have done something other than the consolidated set of things you're asked to do. And that seems to be this slippage through a lot of the evidence and the submissions, that somehow, because someone else said you should have done something different, therefore the SES is deficient. That's not the case. The SES is perfectly intact, but something else might be relevant as well. No problem with that. So that's the exact import of what these objectives set up. They ask you to then consolidate and integrate the results and to facilitate third-party involvement in the process, which is important because even that gets contained by these directions. So then the procedures to be applied to the supplementary EES, not to the inquiry, not to any relevant matter, to the supplementary EES, the document. And the preparation of a supplementary EES is intended to build upon the original studies, as well as your review. That's what it's intended to do. The following outlines the process required for the supplementary EES to inform the minister's assessment under the Act. I would have thought that was pretty clear if I'm the officer at DTP in telling me what's expected and that this is the process required. And then you get the 9 directions, if I can call them 12 directions or whatever you want to call them. And number 1 is, of course, the one that requires the content of the SES, which includes both the paragraph and the table. It's not some separate thing. Table 1's just part of direction 1. And to say that that is not a carefully worded set of tasks for the SES is to just disagree with what is a plain, ordinary meaning of what the document there sets out to do. You have to develop a study program to inform the supplementary EES, outlining our plans to undertake the work, blah, blah, table 1. Now, then next steps are about, before we get to exhibit, what the department has to do, which is to review both the study program, which it did, and reported to the technical reference group about, requiring us to do more. Then to the technical adequacy of that work, and indeed the SES, independent peer review, etc. And right down to 9, where DTP, based on advice from the technical reference group and the independent peer reviewers, determined the suitability of the supplementary EES for public exhibition, pursuant to all those things that there sets out. So very clear process that we're to do particular work, and DTP, on advice from the technical reference group and others, had to determine its suitability for exhibition. And then once it's exhibited, the inquiry is appointed, and you are to consider, if you look at 11, public submissions on the supplementary EES. So it's clearly intended from the start. The inquiry will provide a report to the Minister for Planning to consider public submissions on the supplementary EES. And so I'm sorry if that's more straightforward than the submission you heard on Friday, but we would say that it's very straightforward that the Minister gave a set of instructions consistent with what she considered necessary for additional information, and how she wanted to know that it had been assessed before public exhibition, and that she would receive comments and click from you on that material that was exhibited. And so the terms of reference then come about, and they're absolutely on foot with that. Terms of reference in the introductory part tell you that the Minister determined a supplementary EES was required and directed, this is in the 3rd paragraph, directed a supplementary EES was required 6th of March, bracket the Minister's directions. So you are immediately knowing that the Minister's directions were there, the Minister's telling you I've made these directions and there they are. And so it is that the relevant environment matters come to pass. And in paragraph 6 in your purpose, now that you've been appointed, the IAC must assess the relevant environmental effects in the context of the Minister's directions, in the context of the Minister's directions. It's pretty clear that you are not being asked to depart from what the Minister asked in the instruction sheet to the department and others in what you're being asked to do, and in accordance with these terms of reference. And in doing so, should consider relevant aspects of the original EES only where matters and investigations documented in the supplementary EES, rely upon or integrated with the original EES. It's not the role of the IAC to re-examine effects that are outside the scope of the supplementary EES. Now, when our friend was asked on Friday, what about that sentence? Well, what is the scope of the supplementary EES? But we'd suggest a fuller answer would have been, yeah, it's one sentence in a full paragraph. And the full paragraph has asked you to, on the positive, the last sentence is what your role isn't. The first is what your role is. And what your role is to assess the relevant effects in the context of the Minister's directions in terms of reference. So it's it couldn't be clearer that your role is consistent with what the Minister's tried to achieve from the outset, to make it clear what additional information is being sought. And in doing so, by the way, to inform you in the background, even if you go to say paragraph 15, the Minister told you that the supplementary EES was prepared by the proponent in response to the Minister's directions in the study program, April 2024. That was developed by the proponent in response to item 1 of the procedures to be applied to the supplementary statement. So you were informed that that task has been completed. And then I won't take you through the balance of your terms of reference, but you'll see it very clear that when you get to public submissions, you keep getting this reference as relevant to the relevant environment effects and the well, as relevant environmental effects, and the supplementary environmental effects statement. And so it is that in a straightforward submission on Friday instead, you're told, oh, there's a reference to best practice, or what about the scoping requirements, or what about this, what about that? You're at large, you can do whatever you like. Well, within reason, but the real point is this. The SES has not been attacked for adequacy, either in its exhibition or fairly by any witness, if that's understood in the context of the minister's directions. The separate question is, what if at the hearing you hear a good point? What if you hear something that's relevant, that's not in the SES, that's not subject of the task in the SES? Is that within scope? And the answer is yes. It is within scope to consider a relevant submission that's relevant to those matters. It's not out of scope because it wasn't in the SES, if you think it's relevant, but it's not a deficiency in the SES, because the SES is not deficient. It's done everything it was asked to do. And that's where this clash seems to have occurred, this confusion of ideas. And if you look at the way we put our case, we have dealt with matters that were not tasks for the SES, that we think are relevant to the marine effects, impacts and noise, responded to them in evidence, responded to them in submission, and so should the IAC. So this idea that somehow we're trying to confine the scope of the inquiry is a complete fabrication. We're just organising it properly. You can't say, oh, waves are relevant, therefore the SES was deficient. That's not right. The SES is not deficient, but waves are relevant for these reasons. It's fine, how we've done. The problem for the case against us on the evidence isn't that the points can't argue they're relevant. I'm talking here basically marine, leave the shipping channel aside, that's way out of scope. But on the matters they're called evidence about, the problem is they're just not good points. That's the problem. They're not weighty. They're relevant, but they're not important. Yes, you could argue you could include waves. We say we did. Although Dr. Parry says we shouldn't have used our reference sites because they've got waves and Crow Bay doesn't have any waves. So who knows what waves. But we did do waves. It's just not an important point here. And Dr. Edmonds saying she'd do it a completely different way. It's all very interesting. It's just not very compelling. So it's not that they're irrelevant, and we haven't said they're irrelevant. It's just that they're not good points. And they shouldn't cause you to find that either we didn't do what we were asked to do in the SES, or that they somehow prevent you from carrying out your tasks. So without going to the written submission, we would submit to you that in that summary, we respond to about 100 paragraphs of the submission on Friday that seems to try to convince you can have regard to matters that are relevant, and we say you can too. We don't need this kind of, whether it's through a scoping requirement or some other basis. You should just determine for yourself if you think it's relevant, and you should deal. And so that's really what the instructions set up. It's what the terms of reference would expect you to do. And it requires no amount of sort of legalese and analysis to get you there. It's just common sense. That's how you should run your hearing. And then we ask you to really rule on just how weak the arguments actually are, particularly when no witness came and said, oh, I can tell you this is an unacceptable environmental effect. They didn't even say that. Just this focus on whether you should somehow technically have regard to them. Have regard. So that is really almost, apart from getting to the evidence, the main body of work that was the submission on Friday. And in our submission, quite an unnecessary task, given that there's actually no practical issue. It is of interest that the only party that seems to find the instructions from the minister requiring such analysis in terms of reference is one of the ejecting parties in the agencies. No one else had any problem. And we wonder, therefore, whether it is a straightforward response or one that's more consistent with one that looks for angles or ways of, if you like, disrupting what's otherwise a straightforward in our submission set of instructions. So going to our reply submissions, the introductory parts, I can now go to that document. They set up at paragraph 5 how we've structured these submissions. And the part B bit we go to is our response to submissions, if you like, in key themes. But our part C, which is where I really hand over, is where we're responding to particular matters within them. So it's more what we call a focused reply, dealing with the agencies and evidence. So in the dealing with the part B, I can take you our approach at page 2. It will accord with what I think I've just said. But the proponent acknowledges the substantial number of submissions made since the presentation of our closing submissions. Broadly, we see them in 2 categories: those that fall within the Minister's directions and scope of the process, and those that might be described as other matters. The distinction is important given the framing of section 5.1 of the Act and the language in deliberation in the Minister's directions, and it makes it important that the focus that you take is directed accordingly. And so given your terms of reference, we'd say that you don't have to substantially address what we call other matters, but should you choose to do so, just organise your report in a way to clearly distinguish us for the Minister that you're making a comment on something that falls outside the relevance of the 4 matters, as it were. The matters that raised in submissions that do relate to relevant environmental effects, they seem to fall within 2 broad categories. The first, although we'd say it's not always clear, but the first is those which go to the 4 relevant environmental effects and concern nature and extent of impacts. And the second is those that concern the technical adequacy of the SES. And similar to the first of these categories, being submissions that do reasonably relate to the effects, might be audits in the context of matters that were the subject of consolidated recommendations for further work in table 1, and which were the central focus of the SES. But then you might find yourself reporting on matters that were related to relevant environmental effect that were not required to be addressed in the preparation of the SES, or were previously assessed in the EES and addressed by the IAC in your previous report, but were not to be the focus of the SES. Because that's a fair way of saying to the Minister, there's this other matter, but you didn't ask for it, but it's come up. And where the submissions assert technical deficiency with the preparation of the SES, the committee should first satisfy itself whether the deficiency reasonably derives from tasks that were the subject of the Minister's directions, or whether they amount to further or other requirements. In the latter case, the proponent notes it would not be fair to characterise an alleged so-called deficiency as being one that relates to the supplementary statement. Further, in order to amount to a fundamental defect in the supplementary assessment recorded in the SES, such matters need to be very compelling. And it's noted this connection, or at least a well-explained connection, seemed to escape all such assertions made during the hearing. So we've prepared our submissions in that approach. In other words, relevance, not technically deficient, and then how weighty is a big deal. But for the topics that we say are outside the directions, we've noted, and I could just walk through these, that obviously, and we expected it, and we introduced, I think, in our closing submissions, our approach would be not to seek to object or prevent, but that we would deal with it in reply. We deal with that in reply in respect to all those revisitation of matters around broader implications, greenhouse gas, climate change and the like. It's not some attempt by our client to disassociate itself with the importance of those items or issues in matters that were dealt with very carefully and expressly the first time around. It's only to say that it's not what the Minister's asked for by way of additional information. Same with the second point about the demand for gas. And the third point about safety risks. We will say something about that to assist the committee, but this notion of navigation is something that was squarely dealt with in the EES, dealt with by the committee in its report, and it seems to us it would be stretching it to say the minister somehow forgot to ask. It's an express matter that's dealt with and is not the context of the directions. The point seems to be argued through last week, but it's still somehow relevant to marine and stretching the friendship for reasons we'll come back to. Even that's the case with. The fourth is that navigation point, which I will come back to, but the real point that was the subject of last week was trying to somehow convince the committee on scarce information and a bit of Googling or Wikipediaing perhaps, that somehow you ought to be satisfied that you can make this speculative leap of faith that the size of a ship means that the channel's going to be dredged. It's procedurally wrong, and it's not actually really dealing with the facts as the EES has been prepared or as expected, or the project's intended to. But then you had topics that generally do relate to the relevant environmental effects at 14. And they seem to affect or concern in our submission 14, the outcomes of a further work undertaken in respect of potential impacts to the marine environment associated with the project, including seagrass. And we've got some further responses here, but by and large, I think it held good in our submission, that our closing submission, by being quite detailed on those matters, really did deal with the evidence that stood at that point on these matters. The second is the technical adequacy of the supplementary statement, particularly in respect of technical report A and the further work undertaken in respect of the marine environment. We've got some responses to those matters. The technical adequacy of the SES insofar as relates to the completion of further work on the MNES species and threatened and migratory birds. Noise emissions, we acknowledge that that's absolutely within scope of the real environment effects. They were the subject of further work, and there are submissions there we respond to further quite properly here. Air emissions, there has been some comment around those, and we've provided a response. And the technical adequacy of the SES insofar as it relates to completion of further work of ACH. I don't think I need to repeat anything about that unless you ask me to. There was a submission, an informative, descriptive submission we heard last week at a broader level that conveyed important, seems to me, important context, but we would suggest didn't go further for your purposes or the process than we did in the in-camera session. So if it was all right with you, we didn't intend to revisit matters there. If there are questions for us, you should let me know, but we are presuming that that was, in a sense, very helpful context, but it didn't appear to be connected directly with the group that's tasked with the statutory steps and the agreements that need to be made. So before I go to the focused reply where I'll hand over to those responses to EPA and others, there's a couple of points that I can make rather than have to come back and hear more from me. And so I'll go to, there are two tasks I have to do. One of them is the refer to what we call table document 105, which was the Ports Victoria correspondence, and we deal with that at page 36. Another one is to make a couple of clarifications around mitigation measures. I'll leave that last task till the end, just in case something arises. But I'll deal with the table document, the Ports Victoria file. We've got a summary position here, but I'll also make some oral remarks about it. The first point is, as we, I think, indicated on the day we discovered the correspondence had been filed, you'll note that the correspondence was then dated, I think, 10th of January. So it's sort of the first blush return from holidays or whatever. And while I have no further, I don't need to make this in any other context than I did that day. Our assumption at the time, which I think is correct, so it was probably filed out of an abundance of caution or a courtesy to the committee. We didn't understand there to be some material change in between times that would have necessitate any further correspondence that had been filed on the first occasion, and we still seem to think that's the case. The second thing I am able to say within limits is that at that point, at first blush in the year, the reference was to, I think there was reference to a draft memorandum of understanding between the parties. And in fact, I can advise that has been executed, in fact, by both parties as an early matter for this year. It's happened by now. That's just, I say that by way of information update because what follows under those memorandum of understandings, because of matters of sensitivity to port navigation, safety and all sorts of things, are required to be of confidential nature. But I can say, and as we have said in writing, that it is in fact intent. So where the confusion seems to lie on this is, it might become clearer as we walk through the document, but the committee, no doubt on the previous occasion, those members that were constituted as part of that committee, but if not, as a refresher or for the benefit of the new member, will be aware that the way the port operates is that effectively the Port of Geelong is the asset manager for the whole port. It works closely with the Ports Victoria, who in turn delegate a harbour master. The harbour master, who has one for the Geelong port, works obviously closely with harbour masters more generally because there's only one bay and one set of heads that large vessels may enter, and they do so with a pilot that is in turn delegated by the harbour master and according to very specific directions on a vessel by vessel basis, manned by a pilot from the harbour master as to the conditions which a particular vessel must meet to navigate the bay and indeed this channel. So the next thing is at the Geelong port is that large vessels have been visiting the Geelong port for decades and decades, the vast majority of which are visiting the refinery. And we have had vessels with crude or various gases visiting the port over many years, including very substantial vessels. So the next step that probably by way of outside context to how the system operates is that Ports Victoria, without going to its particular charter under its legislation, can in paraphrase terms be said to be responsible, yes, for safe navigation, but also to the efficient operation of each of the ports, and in fact with strategies to optimise, if not do better, to enhance trading circumstances of each of the ports. And so it's Ports Victoria that, based on its studies, would determine whether or not the traffic circumstances were such as to require infrastructure upgrades, including any changes to shipping channels. And they do so on the basis of an investment case, as you'd expect. So the most recent port strategy for Geelong refers to the potential for a future investment case to look at whether it would upgrade the channel into Corio Bay. But at that point, based on traffic, didn't expect that there'd be a sufficient investment case for that to occur. But let's say the Ports Victoria ever did feel that there was a sufficient investment case, it would then go through a series of steps. As I experienced representing the previous body when they did the major channeling project through the bay. They need approvals under coastal legislation, and they also most probably find themselves under the Environment Effects Act, if not the EPBC Act. So this notion that somehow you can slide in through the back door and dredge, substantially alter a shipping channel through a process like this misses so many procedural steps and expectations of how public facilities of shipping channels are managed and planned, and how ports are planned and strategized over a long period of time. And even on that basis, I'd say that to call it upgrading a channel a likely environmental effect of this project falls over at the first hurdle. It's likely effects that you are concerned with, and to link a likelihood from this project to that is fails at the first step. But the second part of this is understanding that the various ways that the harbour master manages larger vessels in the bay. To assume that it's always about dredging is to miss the very particular and specific requirements that apply to how you navigate a large vessel in the bay, from speeds, from whether you have tugs or don't have tugs, from satisfaction that you are meeting the draft that's required, a minimum draft, but also very particularly, and as it occurs for the Viva, the refinery port, the scheduling of vessels relevant to meteorological events and tides. That's how this is a highly specific science and pragmatic exercise. And so it is that all large vessels that enter the Geelong port and the refinery bay do so on the high tide. And so these are harbour master requirements. It's not the choice of the vessel operator. The other fact that's missing here for those who might be Googling is that the draft of a vessel is in part a consequence of how much you load. It's not, the vessel does not have a particular draft, it's its weighted load. With gas, it's a density, and you can manipulate the density of your load to achieve a draft. And so it is with LNG vessels all around Australia, probably around the world. They manipulate how dense the load is according to the channels they have to go. On that premise alone, we would have our second basis, if you like, for why the IAC might deliberately decline from revisiting this issue, apart from there being no basis for it being a likely consequence. It misses a whole host of information about how you might navigate the vessels, which is a matter of very careful simulation to be done, design detail, operational management, conditions to be established at the detailed phase of dealing with the harbour master and port spec, and then achieving specific directions if you do. If you don't, you're going to need shallow draft vessels. So this linking of it to extensive dredging, I think was the expression in Geelong school submission, is a fantasy. There is no basis that this project has been exhibited with a requirement or, if you like, a condition that there'll be some subsequent extensive dredging and widening shipping channels. So that should be enough to dispense with that item, if not because the Minister hasn't asked you, but because by hopefully in those submissions, it's apparent that it's dangerous to enter that turf without a fully exhibited suite of documents, a full explanation and evidence, and a full understanding from ports and others as to what actually happens in the real world, not what happens via submissions of a submitter that might know one or two things about ships. And so in reference to the document from the port, we dealt with that at our paragraph 95. We say it's a letter dated 10th of January. We take it as an update to you as to progress of assessment of navigation matters. We note Ports Victoria is not a submitter, so we're responding to a document, and we proceed on the basis it's a well-intended letter, but misplaced if it was sought to be having bearing on the supplementary environment effects statement. Navigation of the channel is not as of right or consequential on our approval. We need harbour master approval, directions, a whole series of processes to be followed through. Ports Victoria is responsible for shipping and navigation in the bay, and with Geelong Port develops and implements strategies for the enhancement of trade at the ports. It's an aside, but I think it's in the documentation somewhere that the asset manager, as Geelong has required already, that as asset manager, that the berthing can accommodate a 280 metre vessel. So it's not as if the Geelong Port waits for the shipping channel to be upgraded. it relies on navigation of large vessels being able to get to the port. The proponent makes the following comments in respect of Ports Victoria.
Sorry, could I just go back to that last point just to seek some clarification? Are you saying that what Ports Victoria required in relation to the construction of refinery pier was to accommodate a 280 metre vessel?
Yes, and that in fact the asset manager, I think, I might be wrong about this, but I think the asset manager being the port might actually carry out the works. I'm sure.
And is that Ports Victoria or Geelong?
No, Geelong Port.
Geelong
They're
Port.
the asset manager. So the asset manager has required that the berth achieve requirements to berth a 280 metre vessel. So the proponent makes the following comments. According to port strategies, including for the Port of Geelong, it's all of them, Ports Victoria updates its investment case over time in response to infrastructure, including construction of channels. The investment case will necessarily have regard to a number of factors, including port requirements, opportunities for growth, traffic frequency, and it's been the case for a number of other operation improvements undertaken by Ports Victoria over the past decade or so. And so that should be a comfort to anyone who thinks that it's a privatised decision. There is a very public process for these things to follow. The proponent is one operator at Geelong, having been navigating ships of up to 265 metres in length, carrying fuel loads for decades. The crude tankers, you've seen them in place now. The vast majority of larger vessels within the port are associated with the refineries. For operations in the shipping channel, movements are scheduled according to times of day and tides, noting the minimum maintained depth of 12 that's the maintenance depth, is 12.3 metres at lowest astronomical tide. So that's, if I can understand it, that's a low tide minimum maintained depth, but the scheduling has Viva bringing vehicles on the high tide, vessels on the high tide, and the draft at 11.9 metres, which you've heard, I think for LNG vessels can be managed by your load, and it can be less, I assume, as well. The proponent doesn't expect dredging to be required to support physical ship movements, nor to have such frequency of movements as to impact traffic accessibility to other vessels. And that phrase is important in understanding what the port's correspondence is about, because there are scheduling requirements that limit the amount of, if all the large vessels are waiting for the high tide, there's a point at which traffic becomes, and efficiency become the issue, not the navigation. And we interpret that's what might have happened up in Queensland, because it became an export port and suddenly they had several vessels a day. But in this case, you're dealing with the worst case scenario for the purpose of measuring noise and the like. I think the EES, I think called 40 a year. In practice, we know that it's likely that you might get that at high demand, you might be looking at 2, possibly 3 a month. There'll be some months, low demand, you might not get more than 1 a month. So we don't see the traffic being a real impediment to the operation of the port, particularly given that the vast majority of large vessels that need the channel are visiting the Viva refinery pier. So there's an internal scheduling efficiency as well, in the way you make your orders and you get your deliveries organised. So yes, it's appropriate for ports to say we need to look at the use of the port and visitation by others, but it no more than saying that's something you would fully expect them to assess. But there's no reason from the proponent's point of view why that would alter in any material way the accessibility of the port. And certainly you haven't had a submission as such from this occasion. I think they withdrew last time too, the Geelong Port, from the way I read the report. So the proponent recognised the role and scope of Ports Victoria's interest in port movements over time and as scheduled on a daily basis are a matter for Ports Victoria and Geelong, neither of whom are opposed to the project. Turning particularly to the document, we'd say that the matters in it don't concern the focus of the supplementary statement, don't materially differ from the position that was understood during the EES, and concern matters that are squarely dealt with by the previous committee at pages 128 to 132, and we'd say competently in terms of those ultimate findings in that report. By way of information update, the further work Viva's done and is prepared to share at the appropriate time and has to go through a substantial process with is correctly not the subject of the supplementary statement. The time urgency that might have been appeared in that document about Viva not having come back doesn't really match the approach Viva's taken, because Viva's waiting for the minister's assessment. And so it might be that there's just that could be a misunderstanding.
I didn't quite understand what you meant there, that
There was
the apparent urgency in the Ports
Well,
Authority.
the way it might be me, and it's not certainly on the instruction, but the way I read, there were two letters. There's an attached letter that went to us in the letter to you, and it seemed there was this kind of sense of Viva haven't come back, or we're waiting for information, sort of this time urgency. That's what I mean by time urgency. Whereas, in fact, if you're in the proponent's shoes, I've got to get through this process. So it hasn't been this kind of need to be scurrying to get the harbour master's approval. And it might be I'm oversensitive to the language, but the way I read it was almost as if there was a suggestion that Viva was failing to come forth with its responses to information requests or something, which we'd say wouldn't really fit the process very well. And the reasons why it was taking its time are perfectly described by going through this process at this time.
So are you sort of saying that from Viva's perspective, getting the green light for the project really has to happen before, or as a first step, before you would engage in that further process?
I think that's probably overstating it, because it's not they're not engaged in the process. And I might have been oversensitive, because they're definitely engaged in the process. They've signed their MOU, they're doing whatever work, no doubt they're doing research. But in terms of sequencing or putting real energy into the specifics, you're going to need internal board decisions made about the progress of where you are in your project. And
internal board decisions.
Obviously, but so how much do you resource into something that you'll only do if the minister's going to approve the project? So there is always a level of work that has to be done in parallel, obviously, to know, yes, which is the same as you had last time. The preliminary work all shows it's practical and feasible, it can be done, but that absolute end of getting the harbour master's directions and literally thinking about how many tugs you're going to need and what times of day and all that obviously you would need to have know that you're proceeding with the project, and that sounds to me not just corporate practice but common sense. And so when I wrote here about time urgency, a certain letter, it just seemed, I wondered whether Port's misunderstood that we're going through this step, because we're not at the moment engaging in a flurry on matters of detail that will necessarily follow. But it's not to say that that work isn't understood in parallel. But how much you're sharing with, taking the next step, having meetings, sending more computer simulations, etc., would wait. But the key point for you is that in none of these circumstances is it being advanced by Viva that this comes with some requirement or even acceptance by Viva that it would go and therefore fund the dredging of the bay. So it's, and the EES is clear on it. The way it's been approached is clear on it. So we think there, that's why I think the letter, it's a well-intended correspondence. So I don't want anything to sound like a criticism, but just saying another example, the authors mightn't have been right across what was going on in this other process at the time. I don't think I don't want to put it any more than that. It's not really fair to the author, but does that answer that question?
Mm-hmm.
So it follows it for you though. That's why neither the EES nor the SES assume or rely upon, and there's a quote, extensive dredging or widening of the shipping channel. or manoeuvring basins associated with the shipping channel. And that is the position in this reply. I think so. So it's still Viva's position. So it would make no sense to assess environmental effects of works not proposed. They're also, by the way, not declared as part of the project. You go to the initiation of this appointment of the inquiry or the requirement for an EES. The project gets declared. It doesn't include the shipping channel. So based on the substantive work it has undertaken to date, which was set out in your first report, the proponent doesn't envisage visitation of carriers materially affect the operation of the Port of Geelong for other traffic, including large vessels, which are also scheduled in periods of high tide. In these circumstances, we don't further address the matters raised in the letter, except to restate that navigation matters, including mitigations and directions of the Harbour Master, will be the subject of further operations detail and any required process. And so pausing there, we do, even in these submissions, I do unnecessarily, I know, but remind the committee that we wouldn't want this, what I've just said to you today or in writing, to be a response to a submission or a submission that's made because there's some acceptance that these are matters that needed further discussion. It's only in the context of what happened over the last week that we thought it's appropriate to provide you with what I'd call an information update. And if these can be taken in that context rather than some concession around relevance, because we still maintain these are outside the scope. So we point out at 101 that in fact there is an MOU, and you can take that as read. I don't think I need to take you further through paragraph 102 because I said at the beginning that if Ports Victoria wants to go back to any of the channels, any bay, there are steps under a range of legislation, including environmental legislation, that would obviously have to be implemented. But I think it's sufficiently clear without me having to spell it out. That's how we wanted to deal with that. And partly, I did say it was an information update. We don't have a submission, but the other aspect of that is we did feel that we should say something about it out of respect to the number of submitters that raised it. So if we can have our cake and eat it too, not relevant, update as a courtesy, but hopefully, so far as necessary, just to go back to reminding the committee why there are sound reasons why it did not form part of the original EES or this one, and was not intended to. And so the next heading is mitigation measures.
Sorry, just before you go on.
Sorry.
I'm not sure whether it's easy for you to put up the letter dated 20th of November to Scott.
It's certainly not easy for me, but it's easy. Be easy for someone.
I think this is the letter that was attached to the
letter to us.
So it was addressed to Mr. Watt. That's how you pronounce his surname. I'll just wait for that to come up. I don't have a document number. I actually couldn't find it.
I think
I've just got the
It's document 105. And it's the attachment to document 105. But it's the letter to Viva, the attached letter.
Yeah.
All right. I'll need to be yours, if it's all right. Okay. And right now?
No, you're right.
Still can.
So page 2, and please. So thank you for your submissions this morning that you've made verbally on this matter, and they are understood. If we can go just to the last paragraph before the heading MOU. So quite clearly there, after the comma, this is where Ports Vic are quite clearly stating that once you've done your further work on this matter and submit that to Ports. Ports are going to then be in a position to undertake its navigation risk assessment. That's the assessment undertaken by Ports VIC, and consider corresponding and appropriate mitigations relevant to that energy. What that doesn't say, but should we interpret, that would also include any consideration for any necessary approvals they've got to get, or if works are required. Is that a fair assumption of reading of that?
Look, I don't want to interpret this letter too much, Maureen. I understand your question, but I think it's only a letter. It's not a submission, and it's got to be taken at face value. That's the first point. But certainly, as we've read it, that was to us. It doesn't contradict our expectations. None of which are that we're being asked about dredging the bay.
Yeah.
And the risk assessment, you'll get to detail when you know any actual vessels and what draft those vessels will have, or what are the things we've talked about, simulating loads, times of day, tugs. They're all mitigations. And they are the subject of the risk assessment office. So I think the real thing is that whatever they wrote. But so far as there will be any assessment from Viva, it will be in the context of navigating ships in this channel, not some other channel.
Okay. I think you missed my point, but that's fine.
No, that wouldn't be the
if
first
we can move on to the next one, the MOU, statement there in relation to the MOU. So there's Ports VIC would expect the MOU will include first thing about cost, second, defined roles and responsibilities, and scope of cooperation and dedication of resources. So can you address us without breaking confidentialities, what the defined roles and the sorts of matters are you aware of what they are?
No, I can't address you with that. And I wouldn't in this process seek to do so. But beyond that, I've never read the MOU. I know that it's probably high level, is my guess, but it's subject to the limited comment that was able to be made at paragraph 101 in our written submission. And it's too early and inappropriate for me to speculate what any of those items mean. Nor should they consent.
Thank you.
And would the same go, I mean, we sort of invited you, and you haven't taken up this invitation, and I'm not suggesting you should have, but to address us on who would do the dredging, what approvals would be required, what approval processes would be in place, etc. I'm taking it that you didn't address us on those matters of detail because of the position expressed in paragraph 102. It's not for you, it's not for us, and it's not for speculation.
That's absolutely correct. But it's more than that. I thought I'd explain.
I guess I'd add to that, it's not part of the project.
Yes, it's not.
Yeah.
And it's not the way the EES has been prepared or the SES has been prepared, and it's not some oversight. I think Viva's been absolutely clear. So it's future, what I explained to you before about future investment cases for the Port of Geelong aren't for Viva, or for Ports Victoria, the state and Geelong, and all the processes that would follow. And it would be far from appropriate for me to speculate or for the committee to speculate about what might happen in 20 years' time or something. I mean, or whenever. But this SES, our instructions on how Viva says it can navigate the channel are as I've put them.
Okay.
All right. Does that? Thank you. I'll come back on that E because we'll let Mr. Chessel address you on some of the evidence. And if there's anything I've left out, I'll do that also. But can I just, before I hand over, Mr. Chessel, ask if you're content that so far as our written submission has given a reply to each of the submitters, can that appendix be taken as read by you rather than me go through one by one?
Yes.
All right. Well, on that basis.
I mean, we haven't read it yet. but
No,
we
no,
can read it.
and I think they're sufficiently covered in our general comments that I took you to, but we wanted to do the courtesy of going through them.
Yes.
If after Mr. Chessel, I think it's appropriate to go to one or other, I might do it later.
Okay.
Thank you.
Okay, good morning. Are you happy to keep going now? Take a break.
Yes, if that works for you.
Yes.
We will need a break at some point,
Yeah.
but happy to proceed now.
Just let me know when you would like to take a break. I'm going to pick up again at the bottom of this PDF page 7, which is page 5 of the document, the section of the submission that I just applied. And what we do in this section is respond to a number of particular submissions in some detail. And just those submissions really selected because they, there's cover the all the types of issues that are being raised in the other submissions. So you have the appendix with the finalised responsibility for the submissions. General, perhaps not entirely, but for the most part, and section C in the detail are the same issues. Casting in the play is like the other submissions. So hopefully the focus of covers off on the majority of the substantive issues that have been raised in the submissions. Closer? Oh, okay. I'll speak a bit louder. Okay, so the first of the submissions that we respond to is that of the Environment Protection Authority. And what we observe in paragraph 15 is that we've responded both to the closing submission, but also the update that was filed on Friday afternoon. That is the update in response to the questions of the committee. And what we've sought to do in structuring our response is to adopt the 3 main headings that the EPA adopted, that is the marine environment, air quality and noise. And what we've done is focus on those recommendations that were outstanding. And Member O'Neill, you had a question to us as to whether we'd respond to the outstanding matters, and this is what we're hoping to achieve. The recommendations concerning the marine environment are easily dealt with, and that's because the EPA had previously confirmed that it was satisfied with the robustness and the adequacy of the assessment that had been undertaken by the proponent. So that the EPA was satisfied as to the nature and adequacy of the analysis, and it had originally identified 3 recommendations, and it confirmed that recommendations 1 and 3 were closed. And when it came back to you on Friday, it confirmed that the 3rd, that is recommendation number 2, was also closed or satisfied by virtue of the changes that were incorporated within mitigation measures 19 and 21 in the day 2 document. So it seems to us that the EPA has confirmed that each of the issues in respect of the marine environment are now adequately addressed. That then brings us to air quality, and the EPA's original position in respect of air quality identified 4 recommendations, and it had previously confirmed that recommendations 5 and 6 had been closed or addressed. And so the remaining recommendation is recommendation number 4. I'm not going to spend a lot of time on this because this is the issue about stack specific limits versus stack specific limits plus bubble limits. And we did address you on that issue in our closing submission. And with the greatest respect to the EPA, we don't find the explanation that was provided by the EPA as to why it is that bubble limits are somehow inconsistent with the GED, but stack specific limits are not at all convincing. In our submission, the preferable combination of controls is the stack specific short-term limit that locks away the best available technology and the emissions associated with that, and a bubble limit that operates in tandem with the stack specific limits that is designed to ensure that the operating profile of the facility corresponds to the profile that was identified within the supplementary statement and carried through the assessment. we don't understand why the removal of that limit would somehow be preferable or would be more consistent with the GED, which we say is a separate obligation that applies regardless of whether there's stack limits, bubble limits, or a combination of both. The other point we wish to make is that the specification of different types of stack-specific limits, that is a short-term plus a long-term, wouldn't seem to be any more consistent with the GED than a short-term stack-specific and long-term bubble limit. They really operate in a similar way, but would be subject to the additional bias that we identified in respect of affecting the way that the FSRU might operate over time and giving rise to undesirable consequences. And I think we said this in our closing submission. Ultimately, the combination of limits is a matter for the EPA, and if they only want a stack-specific limit, they can do that as part of their consideration and assessment of the relevant development license and operating license applications. But to the extent that the EPA seeks advice from this committee in our submission, the committee should recognise the benefit of the combination of limits that have been proposed. So I don't think I need to say anything further about that issue. The remaining issues then, as raised by the EPA, relate to noise emissions. And what we first identify at paragraph 21 is that the vast majority of the issues that the EPA had identified in respect of noise have now been satisfied. There were in the order of 10 or thereabouts. And what remains are 3 recommendations, recommendations 7, 9 and 10. And what we note at paragraph 22 is that we have provided our specific responses to each of those matters in not just that closing submission, but also in supplementary technical note number 3, which we submitted a little while back in the process. And it wasn't evident to us in reading and listening to the EPA's closing submission that it had necessarily engaged with the terms of the material in SCN3, which seemed to address some of the concerns that have been raised by the EPA, particularly in respect of information provision about the background levels and how they inform the setting of limits, but I'll come to that in a moment. So the first of the recommendations that we address is recommendation 7, and this really is a relatively limited issue as between my clients and the EPA, and it concerns whether or not the specification within the mitigation measures as they concern project noise criteria and the requirement that those criteria be 10 decibels below the applicable limit should apply as a blanket requirement to all limits at all receptors, or whether, consistent with the evidence of Mr. Evans, they really should be tailored to those receptors where existing levels of noise are at or above the relevant limit. And you recall that Mr. Evans gave evidence that the latter formulation would be preferable because it would allow greater flexibility in the way that the facility operates, particularly in circumstances where, under, say, day conditions, there's no suggestion that existing levels of noise are at or above the relevant limits. And so why, in that scenario, would you impose a more stringent limit on the FSRU than would otherwise be required to address cumulative noise? In short, our position is that we favour the evidence of Mr. Evans, so that of the EPA. The mitigation measure that's been formulated adopts the model that Mr. Evans prefers, and in our submission, it's a matter for the IAC, but you understand why it is that we have adopted the position that we have consistent with the evidence of Mr. Evans. So that's what we address at paragraphs 23, 24 and 25. Recommendation 9, or the issue addressed in recommendation 9, relates to the selection of Avalon College South, that is the BG4 location, as the proxy location, if you like, for determining what the relevant noise limits would be at the school, recognising that the school is a location that's affected by industrial noise under certain conditions. And you recall that the EPA questioned whether that location was an appropriate one. At paragraph 26 of our submissions, we've set out a number of matters that we say support the conclusion that BG4 is the appropriate location. The first thing we do is make reference to SCN3 and the particular response that we've already provided to this issue at paragraphs 41 and 42. We rely upon that. We note at subparagraph 2 that the selection of that location was undertaken in conformity with the EPA's guidance relating to the identification and selection of alternative background noise monitoring locations. We note next that the selection of that location was considered appropriate both by Mr. Evans and by Mr. Tardio, and that Mr. Evans had taken the additional step and gone to the site at night to inform his assessment about the suitability of that location being selected as the basis of determining limits at the school. At subparagraph 4, we refer to and respond to the particular issue that had been identified by the EPA. You recall that the EPA had noted, well, the Geelong Grammar School is located closer to the freeway such that it may be affected by noise from the freeway in a way that Avalon College is not. And our submission in response is that that may well be the case, but it only heightens the conservative nature of adopting the Avalon College site relative to another site closer to the freeway, because to the extent that freeway noise affects background noise levels, that hasn't been taken into account, such that the relevant noise limit would be lower than it would be were that noise to be taken into account. And unlike industrial noise, of course, you don't discount the noise from the traffic for the purposes of determining background and then the applicable noise limit. The other observation that we'd make that we haven't put in writing is that the other reason why BG4 is an appropriate comparator or appropriate proxy location is because of its proximity to the coast. And to the extent that the noise environment is influenced by coastal processes, be it wind or even modest wave movements, then those wave movements and wind conditions are picked up within the BG4 location in a way that is suitably comparable to how they would affect the school site. So for each of those 5 reasons and the more detailed explanation that was provided by Mr. Evans and is contained within Supplementary Technical Note 3, we maintain that BG4 is an appropriate location, and we note that the EPA hasn't sought to identify a different comparator. Again, if the EPA wishes to pursue this further in the context of the development licence application, no doubt it can. But for the purposes of this process, we maintain that what's been done is acceptable and consistent with proper practice. That then brings us to the third and final recommendation as it concerns noise, and that's recommendation 10. And this was the recommendation where the EPA sought further information about the data that underpinned the table showing the background noise measurement over time. And we've made a number of points in response. The first at paragraph 27 is that we've actually already provided the EPA with that information. It's information within STN3 and the document identified as STN3A. But for the committee's reference, their document numbers 25 and 36. And there we provided the EPA with both what we understood the request to be in respect of the additional tables, the additional graphical data, as well as the relevant meteorological conditions that relate or that existed at the time that the data was collected. And we've noted at subparagraph 1 that it's not clear to us that that information had informed the EPA's ongoing position in respect of the recommendation. To the extent that it did, that is to the extent that the EPA is still calling for further information again, in our submission, it's simply not necessary for that additional information to be provided. That the EPA confirmed that it would only press for that information if the IAC considered it necessary to inform its assessment. The IAC correctly asked the EPA, well, can you point to any particular guidance or direction that would require the information to be presented in a particular way? And we've seen the EPA's response, and in our submission, it's not responsive to the question that you asked. It's simply not necessary for the background data to be presented in a particular way in order to determine the background levels that will then inform the setting of the noise limits. So ultimately, it's a matter for the IAC. In our submission, you have ample information to understand the basis upon which the assessment was completed and to form a view about the appropriateness of the noise limits that have informed the assessment and ultimately the specification of the project-specific noise criteria. And that's it. That's it from the EPA. So other than those very discrete issues that the EPA has raised, what you have is a submission from the authority that firstly indicates its satisfaction about the appropriateness and adequacy of the assessment, but also that takes no issue with the substantive nature of that assessment. And we started with, I think, 20 or 30 recommendations from the EPA through the provision of information and responding to the EPA's concerns. That's been whittled away to 5. Those 5 from 6, the ones that I've just addressed, are really very discrete issues that we say really have been addressed satisfactorily. And it's of some consequence in our submission that that is where the authority sits in respect of this application. And we'll come back specifically in respect of the submissions made about noise and the appropriateness of the mitigation measures that have been formulated in the EES in that regard. But we note that the EPA is supportive of that approach. That is, it is supportive of an approach whereby the relevant mitigation measure requires the project to comply with project noise criteria set 10 decibels below the effective of the noise limit, such that the effective noise level cannot be influenced by the project at or above the relevant limits. Okay, so that's all we wanted to say in respect of the EPA. We move then to the submission from Environment Victoria, and if you're happy to keep going, I'll work through that one now.
Yeah, perhaps we do Environment Victoria and then we take a break.
Okay, no problem. Really what we do in responding to the submission of Environment Victoria is to recognise that that submission was effectively premised on or relied upon an attachment prepared by Dr. Parry, an attachment that raised certain queries in respect of the adequacy of certain aspects of the marine impact assessment. And at paragraph 30, we make the observation that we noted before the submission of Environment Victoria, which is that Dr. Parry hasn't been called in an expert capacity, nor were the particular matters raised in what we've called the submission attachment, matters that were put to the relevant witnesses that were called on behalf of the proponent to enable you to have a technical response to some of the technical issues, and that's in our submission unfortunate. It was also a submission we learnt that was prepared, that is an attachment that was prepared subject to instructions that were confirmed to have explicitly excluded a request that there be any comment about the acceptability of their likely environmental effects. You recall that the submitter explained that all we asked Dr. Parry to do was comment on the adequacy of the assessment. He was explicitly not asked to comment upon the likely environmental effects or the extent to which those effects might be considered acceptable, having regard to what is in the EES. And in our submission, that's an important qualification to bear in mind when you come to read the submission attachment. And again, we say that all those factors really inform the weight that one can treat that attachment. It certainly can't be treated as expert evidence, let alone expert evidence that was tested in a proper way. All those matters notwithstanding, what we do at paragraph 31 then is respond to matters of detail, if you like, that were raised in the submission attachment. And you recall that those matters related to particular directions, 1A, 1B, 1C, 1D, and 7. And so we've set out our response to those matters in turn. The only issue that was raised in respect of direction 1A was a query concerning the nature of the testing that was undertaken within the existing refinery plume as it concerned chlorine. You recall that in the assessment, Dr. Wallace explained that testing of the seawater was undertaken within a tank to establish the relationship between temperature and chlorine volatilization over time, and that relationship informed aspects of the assessment that were carried forward. And what, as I understand, the query concerns within the submission attachment, it can say, well, we don't know the nature of that testing that was undertaken to establish the relationship that was then carried forward. And in our submission, you've heard from Dr. Wallace. He's explained both the nature and the extent of the testing undertaken in respect of the existing chlorine plumes. The particular questions that are raised in the submission attachment, including about this test completed to establish the correlation between temperature and chlorine disintegration or volatilization, weren't put to Dr. Wallace, and that's a shame, because no doubt Dr. Wallace could have provided a detailed answer. But in our submission, what you do have in part 3.4.3.1 of technical report A is a description of the process that was undertaken. We note that no issue was taken with that process, either by the independent peer reviewer or indeed even by Dr. Edmonds. And in our submission, the IAC should be satisfied that, based on the materials within the supplementary statement, the approach adopted was an appropriate one. We turn then to the matters that were raised in respect of Direction 1B, and those matters can be broken into three parts. The first being the overview of the ecology of Corio Bay, the second related to seagrass distribution within Corio Bay, and the third related to the impacts of existing discharges from the refinery. And in respect of the first of those matters, that is the comment made concerning the overview of the ecology of Corio Bay, we first note that the submission attachment described the ecology of Corio Bay as being intact, notwithstanding the previous extensive dredging programs, and that it is highly dependent on seagrasses. And we agree with both of those observations. They're consistent with the evidence of Dr. Wallace, and they've informed the way that the impact assessment has been progressed. Over the page, at the top of page 11, or PDF page 13, we note that the submission attachment made particular regard, or had particular regard, to figure 3-6 of technical report A, and that was the figure within technical report A that described seagrass cover over time at different locations within Port Phillip Bay. And the observation there was that, well, different seagrass meadows within Port Phillip Bay have different access to nitrogen sources, and that that different access to nitrogen sources was relevant to the way that those seagrass meadows responded to conditions over time. And we don't take any issue with that proposition, but we do observe that figure 3-6, that is this part of the technical report, was really directed toward providing context to factors that are relevant to the spatial and temporal variability in seagrass meadows, and that's part 3.5.1 of the technical report. And those meadows, that is the meadows in Bellarine Bank and St Leonard's, may be affected by nutrients from the Western Treatment Plant and not from nutrients associated with the cycling of seagrass cover within the relevant area, like Corio Bay. It really isn't of any material consequence to the analysis that follows. That part of the report was simply identifying the different factors that inform seagrass cover and seagrass variability, rather than seeking to establish some direct correlation between those meadows and what occurs in Corio Bay. So in our submission, not a great deal arises from that observation. The second topic that was addressed in respect of Direction 1B related to seagrass distribution, more specifically within Corio Bay. And there were some observations made about the approach that was adopted within the EES to describe and ultimately map that cover. And you've heard from Dr. Wallace as to how the particular combination of drone images, towed camera images, ground truthing, and other assessment measures informed the description of the seagrass mapping contained within the technical report, and we don't seek to advance that further. There was a particular query, though, that was raised in the submission attachment that concerned how the outer boundary of the mapped seagrass meadows was determined. It was said, well, that's not clear in the technical report. That is, how was the outer edge of that green area, if you like, delineated? And you recall that Dr. Wallace addressed this specifically in evidence, and he explained that that outer limit was determined by reference to the depth contours, the bathymetry of the bay. And we note further that in part 9.4.3.3 of Technical Report A, there's a more detailed description between the relationship of depth and light penetration as it is relevant to broader issues concerning the impact assessment. So we say that that query is a query that's been answered in the course of this hearing. The last of the matters that concerned 1B were really directed toward the comparative analysis that was undertaken in respect of seagrass cover within and outside of the relevant plumes. And there were some observations about the statistical analysis that informed part of that assessment. I'm going to come back to that later in the context of the evidence given by Dr. Edmonds and the submissions made by the school, but you've heard the evidence of Dr. Wallace, and we've already addressed you as to the particular nature of that analysis. What was new, though, was the contention raised within the submission attachment about the orientation of the two parts of coastline that we utilised for the purposes of the comparative analysis. And in our submission, the contention that the orientation of the coastline at the test and control site somehow counts against a proper comparison is without foundation. There's simply nothing in the materials that would support a conclusion that somehow the differences in wind or tide conditions are such that those differences would give rise to variation in the seagrass cover at the different locations that would discount the validity of the comparison that was undertaken. And in our submission, it was telling that in response to the question of the IAC, the submitter just wasn't able to identify an alternative comparison site that could have been utilised for the purposes of the comparison. Instead, as we'll come to explain, in our submission, one must properly have regard to the limitations of the comparative analysis. We don't take any issue with there being aspects of that analysis that need to be borne in mind when you come to interpret the results, but they certainly don't detract from that analysis to such an extent that the committee can't utilise or have regard to that in forming its view about the extent to which the existing discharges from the refinery, which will be the same into the future, affect seagrass cover. It's useful analysis that informs an assessment of the type that has been completed. That then brings us to the next issue. These are the issues raised concerning directions 1C and 1D, and those issues fall within two categories. Firstly, the comparisons drawn with previous dredging works, and secondly, the proposed methodology for baseline monitoring of dredging impacts. In respect to the first of those matters, we note the following. Firstly, we note that the relevant submitter identified as follows, that the data presented suggests that the impacts on the marine environment should be manageable and short-lived, but this is based on estimates of minor dredging only. And we agree with that observation that it is proper to characterise the dredging program contemplated within the SEES as being short-lived, as being manageable, and as being considered as minor. And really what follows in that part of the submission is observations made concerning allegations about need to widen the shipping channel and for additional dredging to be associated with that. And you've heard from Mr. Townsend as to why those submissions are miscast in the context of this assessment process and rely on ultimately a false premise or a premise that hasn't been made out. Then if we come back to the second of the issues concerning 1C and D, and that really was a call for the baseline monitoring of dredging impacts to have simultaneous measurement of turbidity and light penetration and the like at the same location. Those matters have been addressed in the Day 2 EMF in the way that we've described at subparagraph Roman numeral 1. ME5A and ME05 have been updated to require the simultaneous selection or simultaneous monitoring of various factors relevant to determining impact, and for those baseline monitoring and surveys to determine the appropriate thresholds that will then trigger relevant actions. And just to highlight, that is the one change to the mitigation measures that we'll come back to at the end, that there was a hangover in that part of the mitigation measure that specified particular thresholds that would trigger actions. What's contemplated now is that those particular thresholds be determined through the baseline monitoring program and that they form part of the relevant approvals, which will then trigger the relevant actions rather than being set at the levels that were contemplated originally, which are levels that the relevant submitter took issue with. The last of the issues then concerns Direction 7. So we're out of that part of the directions that concerns the assessment of the existing environment, and we're in the body of the analysis as it concerns the impacts of dredging. And you recall that the submission attachment was written by, it said, the author of the Victorian Dredging Guidelines. And the first thing that we note is that, contrary to the submission that has been advanced by others, the submission attachment takes no issue whatsoever with the way in which the guidelines were utilised to inform the assessment, including the utilisation of the relevant formula contained within those guidelines to establish the relationship between model turbidity and the extent of light penetration to inform an assessment compared to the thresholds of 10 and 20%. So that issue wasn't the issue that was identified. Instead, what the submission calls for is the need for ongoing and simultaneous measurement and monitoring of those two parameters, that is suspended solids and I think it's light penetration. And again, that has been explicitly addressed in the Day 2 modifications that we've made to MM05A and ME05. And that's it. So again, a series of very discrete issues, which we say have been fully addressed in the context of this hearing and responded to. And nothing further, no submission that this project would give rise to unacceptable impacts, no indication that the assessment of the operational impacts are unsound, very little comment on the assessment of the impact assessment as it concerns dredging, other than to recognise that that program really is properly considered minor and not likely to give rise to significant environmental effects, and an identification of particular matters, particular aspects that should be given effect to in the mitigation measures and that have in fact been given effect in the Day 2 version. Okay, the next one would be the North Shore Residents Group. We don't really need to say much about that because the focus of that submission was
just take a break now.
the dredging. Yeah, so we'll come back to that after.
Okay.
Thank you.
All right, we'll break until, what is it, 12:55.
12:55. Okay, great.
5 to 1.
Yes, thank you.
Yeah. Okay. I think we were at the North Shore Residents Group.
Yes, so PDF page 16, and I was just explaining that I don't propose to work through those paragraphs because Mr. Townsend has already addressed the substance of what really was the principal complaint, being the so-called flow-on consequences that would arise were additional dredging to be required as a consequence of the channel. So dealt with that. So what we do next at PDF page 17 is respond to the submissions made by the school. And the first part of the written response concerns the submissions made by the school in respect of the minister's directions. Mr. Townsend's addressed you on that already this morning, and so I don't propose to walk you through that part of the written reply. What I would like to do, though, is focus on the substantive aspects of the submissions that were made, starting with the submissions made concerning noise. And they commence at PDF page 25 at paragraph 53. And in our submissions, the appropriate starting point when you come to consider the school's submissions is to consider what the proper focus of this assessment process should be as it concerns noise emissions. And in that respect, we've identified three matters. Firstly, that the minister's direction concerning the preparation of the EES identified that the specific objective of the supplementary statement was to provide an assessment of the environmental effects of the project on noise, that the terms of reference, that is your terms of reference, require you to prepare a report containing your analysis and conclusions with respect to the relevant environmental effects of the project, which include the likely impacts on noise. And furthermore, that the scoping requirements that are referenced within the minister's directions as relevant to the assessment say this about noise, that the key issue in respect of noise is the potential for increases in noise and vibration levels during project construction or operation to affect amenity adversely in adjacent existing land use, residential and parkland areas. And in our submission, each of those specifications are entirely consistent with what is the governing legislative regime here, which of course is the Environment Effects Act, and which calls for ultimately the completion of a supplementary assessment of the environmental effects of this project, as opposed to a more general assessment of noise within the precinct more broadly. And in our submission at paragraph 55, we note that in this context, it is significant that the school's submissions didn't suggest or take issue with the propositions that noise from the project would give rise to unacceptable impacts, or that it would not comply with any regulatory or legislative requirement. Instead, as we understood the submissions, the school accepts that the project will operate within the applicable noise limits, and furthermore, that the specification of and adherence to project noise criteria will ensure that noise from the project will not contribute to any exceedance of the applicable noise limits. So those two aspects, which are important to the manner in which noise was assessed for the purposes of the supplementary assessment, were not challenged or the subject of contrary submission. And perhaps the reason for this is that that was the undisputed evidence of both of the witnesses who appeared before you. And so there's no dispute in submission, and there's certainly no dispute in evidence about either of those matters. 57, we observe that the criteria, that is the project noise criteria, have been formulated for the purposes of the EES, that is a supplementary statement. And it's important to recognise that that wasn't the case. They weren't proposed in the case of the original EES, nor were they proposed before the IAC as previously constituted. And so this approach whereby project noise criteria are to be formulated at such a stringent level, that is 10 decibels below the applicable noise limits, is new. It's a tailored response proposed and advanced as part of this supplementary assessment. And in our submission, it's important to recognise that those criteria, as they apply to this project, are in fact a different and more stringent response than that which had previously been advanced, which would have allowed noise from the project to considerably exceed the project noise criteria. That is, previously in the reference to cumulative compliance on the part of the refinery and the FSRU wouldn't have required the FSRU to be 10 decibels below. That is, that the FSRU could be substantially louder under that formulation, subject to the levels from the refinery. So the approach that is now proposed for the FSRU and the control to be implemented as part of this process is a more stringent control than previously proposed as it concerns this project.
Can I ask you a question about that?
Yes, you can.
Isn't that because previously the cumulative limit which was determined incorrectly and was therefore wrong?
No, that's not correct. What in our submission, what occurred previously is that the relevant measurements hadn't factored in or hadn't accounted for the existing noise levels being at or above the relevant limit, right? And
So they
so
were
during the
wrong.
course of the hearing, that was detected,
Yes.
and the response identified at the previous occasion was a cumulative compliance, bringing both things down, if you like.
Right.
But
To the right.
that would not require the FSRU being 10 decibels below the applicable noise limit. It could be, as you're aware, no doubt, Member Bergmeister, a very different combination of noise emissions from the FSRU and the refinery. The other thing that hadn't been factored in on the previous occasion was the extent to which other industrial sources unrelated to the refinery give rise to industrial noise that is at or above under certain conditions the relevant noise limits, and the need for the control to properly respond not just to noise from the refinery, but noise from other industrial sources unrelated to this proposal. So it's true that that issue arose during the course of the previous IAC hearing, that's right, but I don't think it's correct to say that the relevant control had been formulated in that way, that is to not include reference to project noise criteria because of that. That simply hadn't been assessed or determined given the way that the issue arose the previous occasion. Now, in our submission, the specification of project noise criteria for this project, for this environmental approval, is a superior response to that which had previously been formulated and advanced in the previous hearing. And there are a number of reasons for this, and we set those out at paragraph 57. Firstly, it's a response that is properly directed to noise emissions from the project. You recall the terms of your assessment are to assess the appropriateness and impact of noise from the project in the context of an environmental effects assessment process, an environmental approvals process for this project, not for any other project. And in our submission, by tailoring the control to require the project noise criteria in the way that has been proposed, is appropriate in that legislative context because it is directed toward noise from this project as opposed to other noise. It responds properly and comprehensively to the existing noise environment, that is noise from the refinery, as well as noise from other industrial sources unrelated to the proponent that need be taken into account. It's proper because it's not in any way dependent on noise levels that may be generated by any future industrial premises. So if there was some cumulative noise requirement that informed the operation of the FSRU and some new entrant into the market or some new industrial noise source was to emit noise levels that gave rise to a breach, the response proposed here in respect of the project would be entirely valid and legitimate. It doesn't, the efficacy of the approach proposed here doesn't rely upon other industrial noise sources emitting at or below certain levels. It's properly focused and independent of that. We say next at 5 that it corresponds to the approach that is specified within the relevant EPA technical guidance in respect of how new entrants within noise environments of this type should respond. And importantly, it's the approach that is favoured by the EPA for this project. So the EPA has come before you, it's shown you the technical guidance, it's explained why, in the view of the authority, that is the appropriate approach to take for this project. And in our submission, the EPA is entirely correct in that regard. And finally, it responds properly in our submission to the applicable obligations that apply to the project under the Environment Protection Act and the Environment Protection Regulations, and in particular, those set out in Regulations 118 and 119. 118 being the obligation to comply with the relevant noise limit, and 119 being the obligation to take reasonable steps to ensure that it responds to the cumulative noise. And in our submission, there's no doubt about the first, that is that this project will comply with the applicable noise limit, nor subject to the adherence to the project noise criteria, could there be any sensible suggestion that reasonable steps will not be taken in respect of this project to ensure that it responds appropriately to the cumulative noise environment.
Can I ask you another question?
Yes, you can.
So that means that, and remembering that I wasn't on the panel for the first
Yes.
EES, but that means that for this EES, the noise limits that apply to the FSRU, which you've just explained, are reasonably selected as 10 dB below the
Yes.
criteria, so as not to have any contribution to the cumulative noise level,
Yes.
are necessarily more stringent than what were applied in the initial EES.
Correct.
So now the FSRU that you are going to supply and install is going to be necessarily quieter in its noise emissions than what was originally suggested.
Well, it's still the issue of the GED, so
Sure.
you would still need to comply with the GED. So whether or not the relevant limit would be lower, that's true.
The design limit that is going to be adopted will be lower in order to, one
Well,
would assume.
There would be a mandated design limit that didn't exist previously, right, for the FSRU. There would be still the obligation under the GED to minimise risk posed by emissions. But what the extra step here is to formulate, as you say, a more stringent set of limits that would apply specifically to the FSRU that hadn't been proposed previously.
Yeah, what I'm trying to understand is whether magically your FSRU is now 5 or 8 dB quieter than what was assumed in the first EES potentially, and then try and understand what would be done to the FSRU to make it that much quieter than what was assumed in the first EES.
Yes, the answer is that the modelling completed in respect of the FSRU and as documented within the technical report and the addendum to the technical report assumes a series of refinements to the different operating scenarios that were tested for the modelling. And those refinements lead to that modelling being at levels that were lower than originally contemplated. And so the answer to your specific question is the reason why the modelling is lower than as originally completed is because of the commitment to meet the project specific criteria and the refinement both in design and operation of the FSRU and the identification of those attributes, those mitigation measures and operational controls specified within the technical report. And I think within one of the supplementary technical notes that explain how it is and why it is, the refined modelling, which is lower, is appropriate and representative of the noise levels that can be achieved in this facility.
Thank you.
The seventh point that we note is at the top of PDF page 27, and that is that the approach that's now proposed is an approach that's considered acceptable by both witnesses who appeared before you, endorsed in full by Mr. Evans, and you recall Mr. Taddeo was agnostic about which approach to adopt, but Mr. Taddeo recognised that the project noise criteria approach was necessary, at least in respect of all other receptors that were affected by other industrial noise. So it's not a case of choosing one or the other. It seems to me, at least, when one doesn't look myopically at the position of the school, it has to be an acceptance that the project noise criteria is an approach that is appropriate for all of the other receptors, given the potential for other industrial noise to affect the noise environment. And so what's left? The question of whether a specific tailored control should apply to the school in circumstances where their own witness accepts that, the satisfaction of the project noise criteria would ensure that any contribution from the FSRU would not result in any contribution to the effective noise level at or above the relevant limits. So that really is, it seems to me, the proper way to frame this issue, rather than saying, oh, it's one or the other. Everybody accepts, or at least witnesses accept, it has to be project noise criteria. And what, there's some additional control that should apply, or some tailored solution for the school? We'll come to address why that shouldn't be the case. So what struck me when I listened to the submissions made by the school on Friday is that the matter that we address at paragraph 58 is that the school wasn't concerned, it seemed, with noise from the FSRU. Indeed, it barely touched upon that at all. Instead, the school's submission was focused, I've said exclusively, no, that's correct, on noise from the refinery. And what the school said in its submission was that, oh, well, this process provides an opportunity to impose regulatory requirements in the context of the approval for this facility that really aren't designed to address noise from this facility at all, but instead designed to compel noise reduction at the refinery. That is ultimately what the school is contemplating. It's saying, we're not concerned about noise from the FSRU, we are concerned about noise from the refinery. Use this regulatory approval process as it concerns the FSRU to impose a requirement that would compel something to occur at premises that are not subject to the approvals for this project. And in our submission at paragraph 59, we submit that that's simply not the correct approach for the IAC to adopt. For the reasons that we've already addressed, having regard to the proper scope of this process and the relevant matters set out within the directions and the terms of reference in the law. And it's further emphasised in the present circumstances by the fact that there's agreement between the proponent and the school, it seems, that adherence to the project noise criteria would ensure that the project wouldn't impact in any way upon the extent to which noise emissions from existing industrial sources exceed relevant limits. And so it seems to me and to us in our submission that in order to accept the school's position that there should be some further requirement in the approval for this project that would affect or seek to modify noise from the refinery, that you would really need to be satisfied that the project noise criteria are not an appropriate regulatory response in respect of noise anticipated to be generated by the project. But in our submission, nothing in the evidence from either Mr. Evans or Mr. Tardio, or in any of the other submissions that you've heard, including from the EPA, would support that conclusion. Indeed, to the contrary, there was agreement between the witnesses that the approach would need to be applied, at least in respect of all receptors other than the school, and the EPA indicated that it supported the specification of project noise criteria. And so in our submission, the committee should conclude that rather than establishing project-specific conditions that turn on cumulative noise emissions from various industrial noise sources, some controlled by Viva, some not, the specification of the project noise criteria is a superior and proper response to the regulatory environment and to the existing conditions. What I do want to make clear, members of the committee, is a matter that we've addressed on a number of occasions throughout this process, and that's set out in paragraph 62, which my client has repeatedly stated throughout this process that nothing in the position that it takes before the IAC counts against in any way or reduces its commitment to ensuring that noise from the refinery complies with all applicable requirements. That remains the case. But what we want to make clear, as we've previously put to the IAC, is that those obligations exist regardless of whether this project is ultimately proposed. Those obligations are obligations that are, in our submission, not properly addressed in the context of environmental approvals for this project, in circumstances where we have demonstrated, we say, that a more sophisticated, tailored, project-specific approach can be adopted and properly adopted in respect of noise from this project. You recall that you were provided with technical note 5 and that technical note addressed noise from the refinery. And it's of course the case that the refinery has been in operation for many decades, that It contains a number of complex processes and equipment. And various measures have been identified and are being pursued by the proponent with a view to reducing noise emissions from the refinery. And again, those measures, the measures in STN 5, will be pursued with or without the project. The project doesn't in any way bear upon the implementation of those measures at the refinery. My client is committed to their implementation regardless. And we note the following at the end of paragraph 64, that the project does not, and subject to the implementation of the P&C, will not bear upon either the capacity for those measures to be implemented or their effectiveness. So again, separate to this process, a series of measures are being investigated, committed to, implemented in respect of the refinery, which is a particularly complex industrial plant. And it's anticipated that those processes, which will be implemented at an appropriate time, having regard to the nature of the plant and equipment, will reduce noise from that facility in a way that's entirely consistent with the obligations that exist under the Environment Protection Act for that facility.
Can I ask you another question there?
Yes, you can.
So the existing facility has an obligation under Section 25 of the Environment Protection Act, GD,
Yes,
to understand the risk of harm,
yes.
which you pointed out are not subject to the approval of this particular project. But would it be unreasonable of me to expect that in doing that and fulfilling its requirements, its duty under that environmental duty, they might prepare a noise management plan, which might include a risk assessment, so that if asked to demonstrate that they understand the risk of harm, they may have something to demonstrate that and to document more fully what their response to that risk might be. So you gave us a response in STN 5, which was not a noise management plan and did not provide any reference to a noise management plan that maybe have been prepared or in preparation by Viva for the existing refinery, which may give us some satisfaction that Viva is taking its responsibilities in relation to that duty seriously.
Yes, but we'd say a number of things. Firstly, the obligation under Section 25 is an obligation to implement the GED. So to take all reasonably practical steps to minimise the risk of harm, including from the emission of noise.
Yes.
And what we did in STN 5 is describe steps being taken by the proponent that will reduce noise in the context of the facility. But
yeah, so I want to understand how those things were determined.
Yes.
So my question originally several weeks ago, or maybe last year, was around, is there a noise management plan?
Yes.
Or has there been a noise management plan specifically
Yes.
prepared for the refinery? And we were provided STN 5, I believe, in response to that question, which is not a noise management plan.
No, it's not a noise management plan. What STN 5 does is explain the refinery, the sources of noise at the refinery,
Yep.
the question raised by Member O'Neill, and identify particular steps that were taken. You asked us during the course of the hearing a number of targeted questions about how it is that the proponent goes about assessing the risk profile, if you like, of different pieces of equipment within or different parts of the refinery, and there is the separate response that we provided to that query, and we can come to that in due course. It need be borne in mind in my submission that the refinery is a decades-old facility that operates pursuant to the terms of a particular operating licence, which has obligations in respect of various risk management obligations. There's not, as I understand it, a specific noise management plan that has been formulated in respect of the refinery, nor is that called for under the terms of the relevant licence, nor is it something that the EPA has sought that my client prepare in respect of the refinery. But what my client does do, as we've set out in the relevant response, is identify at each opportunity where there's scope to upgrade or modify aspects of the plan, consider a whole series of risk management factors, one of which is noise and the extent to which different measures can be implemented to reduce noise. So I don't think it's as simple as saying, well, there is no noise management plan or a risk management approach to addressing noise from the refinery. There isn't a single document, as I understand it, that is headed noise management plan, but there are a series of protocols that my client implements to address the risk caused by noise from premises that's been in operation for decades. And I suppose, Member Burgomaster, you asked me the question ultimately under various, how can we be satisfied that that's occurring? Well, that's not the subject of this assessment process. If it was, we would produce different materials and we would have addressed you on it differently. Instead, this assessment process concerns noise from this facility, and that's why we focused on the way in which the particular response here is a tailored response that is an appropriate one having regard to the existing noise environment, both from the refinery and other industrial noise sources, but doesn't detract from or count against the proponent otherwise implementing measures to reduce noise over time from the refinery or any other commitments in that regard. They're separate processes, and in my submission, you need not be satisfied that there's a particular plan that implemented at the refinery that would achieve X, Y, or Z. Instead, what in my submission the committee should probably focus on is the extent to which these controls specified for this project respond appropriately to the existing noise environment. In our submission, they do so in the way we set out.
Sure. But you understand that we need to be satisfied that this project, should it gain approval, will meet its environmental obligations, one of which is that it should comply with the GED.
This project?
Yes.
Yes.
Yeah. And so in assessing how the proponent might respond to their requirements, their duty to meet the general environmental duty, it's probably reasonable to understand how they might apply that to other facilities they operate, including one adjacent to it, where you're telling me they have no noise management plan. Even though
no specific noise management plan, but they have a risk management protocol that identifies various matters that are taken into account over time. So
sure, and that risk protocol hasn't extended to creating a noise management plan for a situation which they know exceeds some noise limits that apply to the facility.
we'll come to that in a moment, that aspect of it. But in our submission, when you come to consider whether this project is a project that would not only comply with the applicable limits, but is one that would give effect to the GED, the obligation to minimise the risk, taking reasonable steps. In our submission, the commitment to achieve the levels that are so stringent relative to the limits that would otherwise apply, 10 decibels below, is undeniably, in our submission, a commitment that is entirely consistent with the GED and that would ensure that noise emissions from this facility will not give rise to risk of a type that would be contrary to the GED, or put differently, that the steps that will be necessary in order to comply with the project noise criteria are steps that are entirely consistent with the obligation to take reasonable steps to reduce the risk so far as reasonably practical. They're entirely consistent with one another. And our focus has been on this project properly, given the nature of this assessment.
Maybe if I could just jump in there, totally understand what you're saying about we're not here to assess compliance at the refinery. We're here to assess the noise impacts of the project. But I guess where Member Burgomeister's line of question is coming from is, remember Mr. Tardio, I think it was in response to a question from one of us, had said in his view, it's not appropriate to approve a new noise source when from the same proponent where an existing facility is not meeting its obligations. Is that kind of where you're coming from?
Yeah, partly.
Yeah.
I'm not sure what.
But also, I think there are two legs to meeting your environmental duty. One of them is to make sure that your noise levels comply with the obligations of the noise protocol. You're not creating intrusive noise, which I think you've demonstrated reasonably well. Perhaps that it should be achievable. But the other part is around understanding the risk of harm. And the way that I envisage that being done elsewhere is by preparation, or understand that risk can be done by having a noise management plan. And that is what I would expect of other industries to fulfil that second leg, I guess, of the duty, which is beyond just achieving a noise level, right? Which is the intrusive noise, which is understanding the risk of harm. And the way my reading of the legislation suggests that you should have a proper risk assessment done in accordance with the risk assessment guidelines published by the EPA.
Right.
Now, that is probably what I was perhaps expecting to get back as part of STN5, but STN5 was perhaps a little lightweight in the way that it responded.
But I suppose the question is, what project are you assessing? You're assessing this project, and in our submission, there can be no suggestion. There is no suggestion that this project doesn't comply with the noise limits. There's no suggestion that what is proposed here is anything other than consistent with the GED. And so for the purposes of your assessment of this project, you can be satisfied of both of those things. What you're asking me is, well, what is going to occur at the refinery over time? A refinery that's been in operation for many decades, a refinery that has a number of complex pieces of plant and equipment, variety of processes that are not necessarily remedied through a single noise wall or a single easy fix. You have a proponent who at each opportunity has a protocol that requires it to consider and implement measures to reduce noise and risk associated with that equipment, and a demonstrated commitment through STN5 of specific things that it will be doing to address noise over time. And
those things were prepared as a response to STN5. There was no existing document in terms of a noise management plan that could be attached to STN5 to say, actually, over the last 5 years, or since the introduction of the...
No, there's no plan. That's right. There is no specific plan. But that doesn't mean, in my submission, that you would therefore conclude that the proponent isn't acting in accordance with its obligations under the Environment Protection Act in respect to the refinery, that it's not exploring opportunities, taking reasonable steps to minimise risk. I mean, if really this was an exercise about the refinery and about determining whether or not levels of noise from the refinery are appropriate or not, there's a whole other series of questions you'd ask yourself, including, well, are the limits appropriate as they apply to the refinery, which has been in place for decades and where nobody has made any complaints? Is this a case where the regulatory regime in respect to the refinery should actually be modified? Because
I think we just need to refocus the discussion on the noise impacts of the project.
In any event, what we say is that, again, the response proposed here doesn't detract from those obligations. It doesn't detract from anything that my client is doing or will be required to do in respect to the refinery over time. They're separate, and the response here is an appropriate one having regard to that separation. At 65 of the written submissions, we've addressed the questions or assertions about non-compliance at the refinery. We say that this is really a matter for the EPA. It's not a matter for the IAC. It's a matter for the EPA as the regulatory body charged with administering the Environment Protection Act. Should the EPA consider there to be a matter that should be addressed in a different way? Should it require a plan, for example, a management plan? Well, it has a range of regulatory responses that it can implement, and it's the relevant body that makes those decisions. It's not the IAC assessing the environmental effects of this project, it's the EPA. And in our submission, that's an important distinction that needs to be borne in mind. At 66, we observe that it is the case that under the relevant technical report, there are elevated noise levels recorded from the refinery under certain meteorological conditions, and Mr. Tardio gave evidence that those elevated levels were higher than at those times than were recorded within technical report D. But again, the question of compliance is a more complicated question than simply looking at noise levels. There are a number of complex issues that would arise should this be the focus of the assessment. Here's an example at the top of page 29, PDF 29. To what extent and in what manner should one account for noise propagating weather conditions in an assessment of compliance? So in New South Wales, for example, those weather conditions are discounted for the purposes of determining compliance. In Victoria, the course up until under the previous regime was that they weren't discounted, and that question simply hasn't been tested in the context of the current regime. You'd need evidence about, if you're really concerned about risk and harm, you'd want evidence concerning the duration and extent of any alleged non-compliance, or you'd want evidence concerning the effects that are asserted to arise from the non-compliances. Noting again, the proponent hasn't received complaints in respect of noise from the refinery. So were this properly to be an issue about the refinery, an assessment of the refinery as opposed to an assessment of this project, there's further material that a committee like you would need, or really that the regulator, the EPA, would need in administering its tasks under that Act. It's not your role to approach this in the way that the school contends, but instead, in our submission, the approach that we have adopted and that's specified in the supplementary assessment is superior, having regard to the relevant context of the approval for this project. What we do next in the submission is respond to submissions made about the power on the part of different decision makers to impose conditions on either a future development licence or a planning scheme amendment. You recall the legal submissions, and we just note that as one of the cases that the school itself identified, that being Bulga decision, this is far from a straightforward proposition. You recall that the relevant extract there starts with the premise, and we set this out at footnote 36, even if there were power to impose a condition that required for its practical implementation an adjustment to operations of a separate mine, or which depended on the operation of a separate mine in achieving compliance, the difficulty is, and it goes on to describe the relevant difficulty, but a qualification or a reservation about the power under that legislative regime to impose a condition of that type. But again, rather than making this a legal argument, in our submission, as we set out at paragraph 70, here my client contends that the proper construction of each of the Environment Protection Act and the Planning and Environment Act, as they concern the powers of the relevant regulator or decision maker, really isn't a matter that need be considered or determined by you. Instead, for the reasons we've previously stated, in our submission, your focus should be on what is the appropriate regulatory response for noise from this project. And in our submission, the project noise criteria is the appropriate response. Then what we do at paragraph 71 is respond to a number of specific assertions. I'll just walk through those in turn. The first thing that we're responding to is an assertion that conditions requiring cumulative compliance were said to be common. And in our submission, that's just entirely without foundation and with respect is not correct. They're not common. Instead, as the EPA explained to you, the specification of project noise criteria that are 10 decibels below the applicable limits are the common means of ensuring that a new entrant within an existing noise environment responds properly to the potential for cumulative noise. It's exactly what is proposed here that is common. And we reject the assertion that somehow conditions of the type called for by the school can be characterised in that way. The next matter was a response to the submission that here the proponent is effectively expanding the existing refinery premises. And again, we say that's not correct. What's important to understand here is that the refinery and the FSRU are separate and distinct scheduled premises for the purposes of the Environment Protection Regulations, and we set that out at paragraph footnote 39. And they'll be subject to different regulatory instruments across both the development and operating licences and the planning scheme amendment. Those things are targeted exclusively to the operation of this facility and not to the refinery. That's a regime that's separate to its own regulatory approvals properly. And in our submission, it would be highly irregular that the environmental approval issued for one facility be contingent on the environmental performance of the other. It's relevant to the assessment of the project that there will be integration of the seawater intake and discharge processes associated with the refinery, which it is acknowledged will require permission from the EPA. But the fact that there is that integration that's relevant to an assessment of environmental effects doesn't somehow contradict or count against the proposition that these are separate premises subject to separate approvals, such that the approvals of one shouldn't be contingent upon things occurring in the other. That there is integration relevant to environmental effects does not count against that more fundamental proposition that's relevant to this question of what approval conditions should be on the FSRU and the approval of this facility. Then the school made reference to the decision of the tribunal in dual gas, and in our submission, that reliance was misplaced. And that's because in that case, the justification for the greenhouse gas emissions that were anticipated to be generated by the proposed power station was that the operation of the facility would compete with and displace higher greenhouse gas emitting sources of electricity. And in that context, the tribunal imposed conditions securing that outcome, that is, that this facility could only operate if it did displace higher emitting sources of greenhouse gas emissions. The context here is very different. In this case, the project has the capacity to ensure that its noise emissions will not contribute to any exceedance of the applicable noise limits, whether those exceedances are attributable to the refinery or to any other existing industrial noise source. And so the operation of the project should accordingly not be contingent on the performance of other premises. Next, the school asserted that the project noise criteria will complicate the noise environments and give rise to associated complications in enforcement. And in our submission, those contentions were overstated. You recall that both Mr. Tardio and Mr. Evans agreed that the monitoring equipment exists that can measure noise from the project and that assessment processes can be implemented to ensure compliance. The mitigation measure formulated and agreed by those witnesses has been given effect in the day 2 version. So to suggest that somehow there's some insurmountable hurdle that won't be able to be overcome is not borne out by the evidence. And indeed, again, we note that even Mr. Tardio accepted that the approach will necessarily need to be implemented for this project, given that there are other industrial noise sources nearby. So we've got to be doing it anyway, even if there was some other cumulative noise obligation, it seems to us, because of the need for this regulatory instrument to respond not just to the condition of the school, but also to all other receptors and all other industrial noise sources. The next one, subparagraph 5, responds to an oral submission made by the school where it was suggested that the planning scheme amendment would be the most appropriate regulatory instrument in which to include a cumulative noise requirement. You recall that there was a question, Member Carlisle, should it be the development licence, should it be the PSA? And I think the answer was it could be either, but the PSA would be preferable instrument. In our submission, it again needs to be borne in mind that the PSA, the planning scheme amendment, will not apply to the land where the refinery is located. Instead, that amendment gives effect to an incorporated document that only applies to the footprint of this project and doesn't seek to regulate or govern in any way the use or development of the refinery. So again, they're separate instruments performing separate roles, and the instruments before you are targeted to, probably focused on the FSRU.
Can I just ask you a question about
Yes.
Planning regulates what goes on a particular planning unit,
Yes.
land, but it also regulates impacts that go beyond that planning unit.
Yes.
Is analogous to a suggestion that the PSA can regulate impacts that go beyond the footprint of this project?
Yes, but it should probably be impacts born from the use and development that is the subject of the permission, right? So where you have a planning scheme amendment that incorporates an incorporated document that governs the use and development of the floating storage and regasification unit and the ancillary equipment, the controls contained with that planning scheme device, the incorporated document, can of course have regard to impacts beyond the footprint of the facility itself, but there should be the impacts of use and development that is the subject of the permission, not other use and development that is not the subject of the permission. So we don't take any issue with that proposition, but we say that only supports our submissions to you because of the nature and focus of the relevant instrument. The next issue we deal with is at subparagraph 6, and there the school again in oral submissions contended that the position that my client advances amounts to a contention that noise from the refinery is an irrelevant consideration in the IAC's assessment of the project. It was put so high as to say, well, what the proponent is saying to you is that noise from the refinery is irrelevant in a legal sense. And that's not what we're saying at all. It is relevant to your assessment. And because it is relevant, along with noise from all of the other industrial premises in the vicinity, all of that is relevant. It has been properly taken into account and responded to by formulation of the project noise criteria. The only reason why project noise criteria have been advanced here is because of the existing noise environment, including the noise from the refinery and from the other industrial noise sources. That is directly relevant to your assessment, but the proper response, having regard to that relevant consideration, is the response that's been formulated in the supplementary statement, rather than some overarching obligation in respect of cumulative compliance. So but to characterise my client's position in that way is not correct. Okay, I think I've sort of done noise perhaps to death, but that's really all those submissions point and are born from the proposition that the focus of your assessment is a focus on this project and that the approvals for this project should properly relate to this project. Separate obligations exist for the refinery. My client takes them very seriously. To the extent that there's a compliance or a non-compliance issue, that Act has measures that respond to it, and the EPA is the appropriate regulator, not the IAC, and certainly not an approval for a separate project. An approval for a separate project should not be used properly to seek to modify noise levels from an unrelated facility. That's the core of our position.
Okay. Hear everything you've said about that. The scoping requirements call for a cumulative assessment of cumulative impacts. So we need to make a decision about, well, not a decision, we need to assess whether the cumulative impacts of this project and existing noise results in an acceptable environmental outcome.
Could I ask you, what part of the scoping directions are you referring to?
Oh, I cannot remember off the top of my head, but I'm sure that there is a requirement in the scoping requirement somewhere for an assessment of cumulative impacts.
Yeah.
Maybe I'm wrong.
Yeah.
But there normally is, and not just in relation to noise, it's in relation to all impacts.
Yeah.
But I can't tell you which part of the scope requirements.
Yes. Okay, well, that's fine. Sorry, the question was.
Yeah, so I guess how does that play into, you know, that's a slightly different question or a slightly different emphasis than where conditions should go on project approvals.
So I think the first way I'd answer that question is to say the scoping requirements also specifically say in respect of noise that the key issue, and I've set this out at paragraph 53, subparagraph 3, is the potential for increase in noise and vibration levels during project construction or operation to affect amenity adversely in adjacent existing land use, right? So that's the more targeted direction within the scoping requirements. And to the extent that the committee need also consider cumulative noise, we don't take issue with that at all. But what we say is the appropriate response to the cumulative noise environment, be that from the refinery and the other industrial noise sources, is the formulation of a control, and control that's been demonstrated as being capable of being implemented. There's no argument about that. A control that demonstrates that noise from this project, which must obviously be the focus of your assessment, won't contribute to the effective cumulative noise level where cumulative noise is at or above the relevant limit. And so the approach that we have events before you is an approach that is directly responsive even to a broader obligation framed in that way. Cumulative noise is relevant to the extent that the control here can be demonstrated to be formulated to ensure that, to the extent there are exceedances, those exceedances won't be exacerbated or contributed to by this project. And it's a complete answer in our submission to those aspects of the scoping requirements and the more general directive to consider noise from this facility.
Thank you.
Okay, I'd like to move now to the next part of the submission, which concerns the submissions made by the school concerning marine impacts, and they commence at PDF page 32. And I haven't sought to respond to each and everything that's been said by the school. We did address a lot of the matters in the closing submissions that we prepared. And so what we do here is respond to new matters, or where appropriate, elaborate on certain matters that were addressed in closing. And what we sought to do for the benefit of the committee is adopt the same heading structure as was in the school's submission. We don't do that always, because sometimes we've amalgamated certain sections of the submission, but hopefully that assists in cross-referencing the two documents. The first topic then that was addressed by the school concerned hydrodynamics. And when you go and look at those submissions, really the school was focused in those submissions on the provision of information sought by the school over time. There was a very lengthy recitation of, we asked for this and they gave us this, and we asked for this, they gave us this. This was only produced then, and that type of thing. And it struck me that rather than revealing any deficiency in the current process, really what those submissions demonstrated was that my client has at all times been entirely responsive to all of the requests made by the school for further information. And in our submission, a fair characterisation of that exchange is that the proponent has sought to facilitate a full and proper examination of the issues that are in dispute as between it and the school. And there were submissions to the effect that this type of process imposes a burden on submitters, and that's true. It does, and that is part and parcel of every environmental effects assessment process. But it would be unfair and improper in my submission to somehow criticise my client for the way that it's responded to each and every one of the requests of information that have been made, not just by the committee, but or by the EPA or by a relevant authority, but even by the school. We have sought to respond fully and have to those requests in a timely way. And in our submission, that lengthy submission really doesn't go anywhere. The only substantive issue that was raised by the school in respect of the modelling concerned the way in which waves were taken into account, and in particular the effect of waves in resuspension of solids from the seabed. And we've addressed you on that topic, and paragraph 76 included the relevant reference to the closing submissions. What we say, though, importantly, is that the evidence before the IAC demonstrates that the effects of waves were taken into account in the revised and updated hydrodynamic modelling in a way that is commensurate with the nature of the marine environment within Corio Bay. There were some issues raised by Dr. Gard about the adequacy of that assessment that seemed to be relied upon by the school, but the fundamental premise and the relevant conclusion in my submission for the IAC to make is that those are relevant to the modelling process. They have been taken into account. They've been taken into account that is appropriate for this environment, and there's no basis to criticise the adequacy of the modelling on that basis. And there was no complaint whatsoever about the way that the updated, recalibrated modelling responds to each of the specific matters that the IAC previously identified as being deficient. But they seem to be accepted as having been responded to appropriately, and that's significant. Then we turn to that part of the school submission that addressed marine ecology more broadly. And commence that part of its submission by making its case about how item 1 of table 1, how that first recommendation should be construed. And we've already addressed you on that, and we've included reference to the relevant parts of our submission that set out what we say the proper construction is. At paragraph 79, we say that ultimately, regardless of how one construes direction 1, really this committee should be satisfied that it has been satisfied or been furnished with a very substantial amount of additional survey work, and that additional survey work allows it, being you, to assess the relevant environmental effects of the project in accordance with the Minister's directions and the terms of reference. There is a dispute, a high-level dispute that we come to next about how an assessment of this type should be conducted, but in our submission, fairly read and fairly, when one takes an objective and balanced view, the amount of information provided before you now, in addition to that which was in the original EES, provides you with ample, in fact, very good information about the environment as it is relevant to the environmental effects of this project. And that is a relevant test. You're in a position to discharge your functions.
Just before you move off survey work, are you going to come back to the surveys over a 12-month period?
Yes,
Okay.
Well, no, but I can do that.
So I can't remember exactly where, but I remember that from the first report of the IAC, there was a reference to the fact that survey work should have been conducted or should be conducted over a 12-month period so that you can assess the impact of the recommendations. Can you remind me whether that 12-month survey period found its way into the Minister's directions, or whether I'm remembering that from the IAC's report? And when the IAC suggested, I'm asking you to remind me of what we said. I appreciate that, but whether it was before work started or before assessment was completed.
Yes, I'm just going to come to the relevant recommendation. I believe it to be recommendation 1C and 1D, and I'm just that immediately to hand.
Just conscious that a number of our submitters from last week in particular raised concerns about the survey work not having been conducted over a full 12-month period.
Recommendation 1C was to undertake further survey work to better establish the existing environment and the impacts of existing wastewater discharges from the refinery to enable better understanding of project impacts. The survey work should address a number of things. 1C, be carried out over a period of at least 12 months before construction or dredging starts, with a minimum of 4 sampling runs, 1 in each season, to address seasonal variability. And so what you see in the technical report A is survey work that was undertaken over a period of many months. But in response to recommendation 1C, the formulation of a requirement for a specific monitoring program to be implemented for a period of 12 months before construction of dredging commences. So the reference to the 12-month period is the 12 months immediately preceding dredging, and that program is secured under the technical report and under the mitigation measures through those requirements to survey a number of things simultaneously at different points to create the relevant baselines that then inform the relevant trigger actions and the like. So it's not correct, we say, to say that the IAC said you had to do 12 months for the purposes of a further assessment. Instead, what the IAC said, and it's what you said in our submission, is that that requirement be in the 12 months preceding the commencement of dredging, and that's what's been committed to and factored into the assessment process. So you see that at various points throughout technical report A. In addition to that, obviously, a great deal of additional survey work and monitoring has been completed for the purposes of this supplementary assessment that will be of real value when one comes to complete the further monitoring program that's contemplated under mitigation measures. But it's not a requirement that applied now. That is, that there was no requirement to do 12 months monitoring now. It was in the period immediately
Leading up
preceding
to construction.
that occurred.
And I think you mentioned that that was secured through the environmental management measures.
Yes.
Can you just give me a specific reference? You might need to come back to us on that.
Yes. Well, why don't we come back to you at the end? I'll come back to you to demonstrate exactly where in the mitigation measures that's been addressed.
Okay, thank you.
Okay, so we are back at PDF page 33 and at paragraph 80 of the written submissions, where we respond to what again in our submission were very lengthy submissions from the school that sought to support the contention that Dr. Edmonds' particular formulation of an ecosystem-wide or a systems-based assessment process was effectively required to have been adopted for the purposes of this supplementary statement. You recall Dr. Edmonds in his written work said in order to be valid, an assessment of environmental effects need apply a particular approach. And in our submission, the contention that there is one way and one way only of discharging or completing an environmental effects assessment process of this type is just wrong, flat out wrong. Now, we've already sought to address you on those matters in our closing submissions, and for your benefit, again, at footnote 48, we've set out the relevant part of our closing submission where we've addressed those matters. For present purposes, though, we make a number of further observations or make a number of further submissions. The first we say is that the school's very lengthy submissions concerning this issue just simply cannot be reconciled with the very clear terms of the Minister's directions. The Minister's directions did not direct that a specific assessment methodology be adopted. They did instead clearly direct that a targeted supplementary assessment be completed in respect of specific issues, and that was appropriately the focus of the supplementary environmental effects statement. In our submission over the page, we note that this position reflects the equally clear terms of the EES report, that is your first report, which firstly addressed the question of the assessment methodology in section 7.3, which culminated in a recommendation made about the utilisation of a particular type of conceptual model within the EMF, and then went on to separately make a series of recommendations, that is to identify with precision the further matters in respect of which further work was required. So we say that nothing can be taken from your previous report that supports the contention now advanced that only a particular type of assessment methodology can properly be utilised. In our submission 3 of subparagraph 3, the school's reliance on the scoping requirements as justification for its position is misplaced. We rely on Dr. Wallace's explanation of how his approach and how his more targeted approach parts of the ecosystem that are most vulnerable to the effects of the project is properly considered both systems-based and risk-based, as called for by the scoping directions. Again, in our submission, you should simply reject the contention that Dr. Edmonds' formulation of these concepts is somehow the only one that is open to be adopted. The school then went on to rely upon the Marine and Coastal Act, and in our submission, that reliance was misplaced. That section 9 of that act calls, in general and high-level terms, for an ecosystem-based approach to underpin Victoria's coastal planning and management system, a system which the committee will recall isn't defined within that act, provides no more support for Dr. Edmonds' approach than Dr. Wallace's, because Dr. Wallace's approach is equally one that is ecosystem-based, albeit one that is more targeted to those parts of the ecosystem that are more sensitive to the effects of the project. It's not one or the other. They are different types of ecosystem-wide, system-based approach methodologies that can properly be utilised. And for the reasons given by Dr. Wallace, not only is his an approach that's open, but it's the better approach, given the nature of this project and its potential to impact on the environment. So those 4 points really summarise our response to the many paragraphs that were advanced in that regard. But the next topic addressed by the school was the adequacy of the seagrass surveys and mapping. And we continue to rely on the evidence of Dr. Wallace on our closing submissions in response to those particular issues. I did just want to pause here and address you about an additional matter before I turn to operating impacts. Part of the submissions advanced by the school, and indeed a very clear focus of the submissions advanced by the school under the heading seagrass mapping, concern the comparative exercise of meadows within and outside of the relevant plumes. And it struck me again, listening to those submissions on Friday, that it's important, I think, for the committee to bear in mind the purpose of that assessment and how it fits within the broader assessment of environmental effects for this process. And so the starting point in my submission is for the committee to consider why it was that that analysis had been completed. And you recall that that analysis wasn't prepared in direct response to a direction or a recommendation from the committee. There is no direction or recommendation that a comparative analysis need to occur in terms of seagrass meadows inside and outside of the relevant plumes. But the analysis was completed because it provides useful information about the effect of the existing plume. And because, as we'll come to in a moment, the existing plume is going to be the same as the future plume, it's really analysis that bears most directly upon the operating phase of the project. There's obviously important, useful information about the seagrass within the Ramsar area that's relevant to aspects of the dredging program. But when you come to consider, well, why is it that this analysis is relevant? It's principally relevant as it considers operation, because it's really directed toward understanding the effects of the discharge moving forward. Because it's relevant to operation, the next step in my submission is for the committee to have regard to and bear in mind that a distinguishing feature of this project, and indeed a very clear point of difference between this project and any other FSRU that's been proposed within Victoria or interstate, is the capacity to link or integrate the seawater intake and discharge components of this project with that of the refinery. And why is that relevant? Well, it's relevant, of course, because if we're here to assess environmental effects, and effects being a change brought about by the project, then the fact that the existing discharge will be the same as the future discharge, or perhaps the future discharge will be the same as the existing discharge under operating conditions, is highly relevant, because there will be no or very minimal change such that there will be minimal effect. So those two overarching matters need to be borne in mind before you come to consider the comparative analysis. Then you come to it and you say, well, what can be understood in qualitative terms and what can be understood in quantitative terms about the comparison? And in qualitative terms, we note that in the supplementary environmental effects assessment, there's a description completed by marine biologists of the seagrass meadows that exist within the plumes. That description recognising that they are abundant and recognising that they possess qualities, comparable qualities of those meadows outside of the plumes, in that there are some areas of intense growth, some areas of less intense growth, some patchy areas, but that qualitatively the meadows that exist within the plumes, just as outside of the plumes, are relatively abundant within Corio Bay. And the analysis shows that yes, there are some localized impacts within some of the discharge. The impact at W5, I think, as a consequence of the physical the propulsion of water, or what the water causes at the immediate discharge point, a physical effect, not a chemical effect. Nutrient build-up at W3, because that's where the seagrass is expunged from the system, so nutrients in, nutrients out. But that other than those very localized effects, there is no observable difference between seagrass within and outside of it. So what then the assessment does is seek to build upon that qualitative analysis through quantitative assessment. And I think I made the submission in closing that in some ways this question has been a disproportionate focus of this assessment process. And I made that submission because really the very detailed assessment about the statistical assessment or the classification system really fails to see the forest for the trees. That is, the committee need properly bear in mind the limits of the statistical analysis and the limits of the classification system. They are limited, they're tools. But what you shouldn't do is disregard the outcome of that analysis, which is a quantitative comparison of seagrass coverage being the proper and best indicator of the health of seagrass meadows within two locations, one selected randomly as a control location. And the fact that that analysis in a quantitative sense is so close provides further a further basis for the committee to conclude that the existing discharges really don't affect seagrass growth or abundance within the existing plains. That's now, will be the same case in the future. And we'll come to talk about some of these specific issues, but really the focus and the very limited focus on certain methodological aspects of the assessment just doesn't grapple with what the assessment shows and how you can use it. So if we look at the statistical complaints, what we see first is a complaint that from Dr. Edmonds that the analysis isn't quantitative, but it is unambiguously quantitative. The whole point of doing the classification system of scoring the transects at these hundreds of locations in the control and in the test location is to quantify the extent of cover. That's why you do it. So the suggestion that it's somehow not quantitative and can't be the basis of a statistical comparison is flat out wrong. I don't understand how that can be advanced. What he says next is, well, the data isn't parametric. And I was waiting to see how that proposition would be advanced because, again, it doesn't make any sense to me. It's simply an assertion by Dr. Edmonds that there's something about the nature of the distribution of the data that's been gathered that doesn't lend itself to a statistical comparison. But that wasn't advanced in evidence. It wasn't advanced in submissions. It's an assertion that isn't borne out by the data. Why is it that these two data sets can't be applied in a statistical comparative sense in the way that has been proposed? And that hasn't been made out by the school in any way or by Dr. Edmonds. It's a assertion without any substance. Then the only other complaint by Dr. Edmonds was that, well, I suppose there were two. One was about pseudo-replication, but we've already explained why that's not a proper way to criticise this statistical exercise. Why? Because hundreds of locations within the control site were compared with hundreds of locations within the test site, spanning 800 metres along different parts of the coast. It's not a single point that is pseudo-replicated for the purposes of the analysis. It's a broad data set taken from within the two locations that responds to that complaint. And then the only other complaint from Dr. Edmonds is that it's not continuous. But again, I don't understand why that can be said or how that can be said to count against the comparison of the time that was undertaken here, which was based upon data of a temporal nature, collected over many, many months, and that provides you with an indication at a point in time of the relative cover within the plume and outside of the plume. And is it a perfect analysis? Well, perhaps not, but that doesn't mean that the committee just ignores it or should push it to one side. Instead, what it shows, consistent with the observations of the marine biologists, is that there's no discernible difference between cover inside the plume and outside of the plume. And then you come back ultimately to what Dr. Wallace explained, which is that his hypothesis was that, well, he actually expected there to be more growth within the plume because of the temperature difference, but that the temperature difference ultimately was demonstrated to not have an effect. So when you add all these things together, rather than being some defect in the analysis that somehow calls into question the sufficiency of the SEES, instead, all of the information, when it's properly understood, points in the same direction, coupled with the balance of the analysis as it concerns operation, where analysis of the acute effects of chlorine showed very small volumes of chlorine being discharged lawfully in accordance with the refinery's license, but then quickly volatilizes and disperses. So there's an explanation as to why chlorine has no effect on seagrass growth within the plume. There's further analysis in respect to the chronic exposure to CBP and a demonstration that that doesn't exist at levels that can be detected. And so when you tie all of the information together, it points very much in support of the conclusion that's expressed within the supplementary statement that, consistent with the expectation of Dr. Wallace, that there is no adverse effect. Instead, the existing discharges are inconsequential as they concern seagrass growth. And I suppose that is what has been missing in the submissions that have been advanced by the school and by others about this aspect of the test. It's a focus about particular aspects of a particular component of the assessment, but a complete failure to engage with what the body of the evidence shows. And in my submission, when you do properly engage with that evidence, the committee should readily endorse the conclusions expressed within the supplementary report as it concerns those matters. I'd like to return then to the written submission. And I'm now at the bottom of PDF page 34 at the heading Operating Impacts. And what we observe is at paragraph 83, despite the very lengthy nature of the school's submissions, when you look at and analyse the school's position as it concerns operating effects, there are a total of 4 paragraphs that address those issues. And in our submission, that's telling or conspicuous or telling, given the nature of this project and its potential to give rise to effects on the marine environment, that there were 4 paragraphs directed to directions 3, 4, and 5, really reflects the evidence of Dr. Edmonds that who didn't raise concerns about directions 3, 4, or 5 of any real substance. And in the context of an environmental effects assessment, that should be a real consequence to the committee, right? Because the operating phase of this project, by far the longest phase of this project, is a phase where there is no meaningful contention that either the assessment within the EES or SEES is deficient, or more importantly, that the effects of the project would be unacceptable or give rise to some material impact. That is absent. And the absence of those submissions and evidence is meaningful. Instead, what the school did do is focus in its submissions more on the impacts of dredging, and we address those at paragraph 85. And the first thing we wanted to observe is that the school did properly recognise the agreement between the witnesses that the project will meet the 20% surface irradiance benchmark for the Ramsar site and the 10% benchmark elsewhere. And that was a proper thing for the school to recognise, and it's a significant thing for the school to recognise. Why? Because of the matters that were addressed by the IAC previously. What the IAC said previously, I obviously don't need to remind you, but it's relevant for present purposes, is that the source path receptor approach to determine the impacts of dredging on seagrass relies on embedded assumptions about hydrodynamic processes, sediment transport, light thresholds for seagrass survival and mapping of existing seagrass. While this is an acceptable approach, key assumptions have been queried, including the adoption of the light threshold of 5%. The IAC considers that the 5% threshold for seagrass survival is not sufficiently conservative. It's referenced then to the Victorian dredging guidelines that state that most seagrass species require more than 10% light for survival. Typically, they require nearly 20% for survival. On that basis, the IAC considers the 10% and 20% thresholds in the Victorian dredging guidelines provide an appropriate basis for assessing the effects of dredging on seagrass, with the 20% threshold given greater weight at the Ramsar site to minimise risk. And that, of course, was the express terms of the direction made by the Minister. That is, the Minister picked up the corresponding recommendation that was made by the committee. And again, the point we make is that many of the issues that were ventilated here about the appropriate approach to adopt in assessing impact on seagrass, should that be an assessment of productivity as opposed to an assessment of survival, previously by the committee, and the committee correctly in our submission found that the approach utilising thresholds was the appropriate approach, but that the thresholds utilised were not appropriately conservative and that 10 and 20% should be adopted. That's what's occurred, and there's agreement between the parties that those thresholds will be met. And again, that itself is, or should be, in my submission, weighty to the committee because it demonstrates the extent to which this project can respond to these conservative thresholds. And it not only, at 87, we note that not only are the thresholds conservative, but so too is the modelling that informed the assessment of compliance with the thresholds. If you recall, it was premised upon a series of conservative assumptions, including weather, including sediment rates, the spill rates from the relevant dredging equipment, settlement rates of the different types of solids, no account for mitigation measures. All these things demonstrate or make good the proposition that the modelling is conservative, and that conservative modelling complies with the very conservative thresholds that have been identified. So what did the school instead focus upon? Well, adopting the position of Dr. Edmonds, really the school submissions focused on alleged impacts or potential impacts on productivity. And we rely upon the evidence of Dr. Wallace as to why additional analysis in respect of productivity is not necessary in order to conclude that the effects of the project over the 8-week dredging program should be considered acceptable. And in our submission, again, our position here is really consistent with that reached by the committee previously, where, as we've set out at paragraph 89, the committee said this: on the question of whether a minimum light threshold approach is suitable for assessing impacts of dredging on seagrass, Dr. Edmonds was unable to direct the IAC to an alternative contemporary standardised management approach. The dredging guidelines adopt a minimum light threshold approach and provide guidance in relation to the currently accepted approach in Victoria. It was appropriate for the proponent to rely on them for the EES, and it remains in our submission entirely appropriate for the proponent to have fashioned its assessment in the way that it did, which demonstrates very clear compliance with, or a very positive response to, the thresholds identified as being relevant. What then follows is heading other matters where we've responded to certain other contentions. The first is at paragraph 90, where we respond to the school submission concerning the qualifications and expertise of Dr. Wallace. and the resultant weight that the school says should be attributed to his evidence. In our submission, Dr. Wallace, in giving his evidence before the committee, demonstrated a very considerable depth of his knowledge of the marine environment within Corio Bay and his undoubted expertise in marine impact assessment. And in our submission, any suggestion that somehow Dr. Edmonds' evidence should be preferred over that of Dr. Wallace on account of their capacity or their expertise to give evidence of this type should be rejected. More relevantly, though, should the committee wish to consider the substance of what ultimately amounted to the key differences between the expert evidence of Dr. Wallace and Dr. Edmonds, in our submission, the recording of the final component of the cross-examination of the two witnesses, that is where the committee brought the two witnesses back together and asked them the same question, was very instructive or highly instructive. In preparing for the resumption of the hearing, I went back and listened to that component of the hearing. And what it demonstrated in my submission is that Dr. Wallace had considered each and every one of the relevant matters that should bear upon this assessment. And we rely upon the evidence that he gave, in effect responding to the contentions advanced by Dr. Edmonds that were put fairly by the committee to both witnesses. And in our submission, what that exchange demonstrated was not just Dr. Wallace's very clear competence to give the evidence, but also the very thorough and comprehensive nature of the assessment that had been completed, and very clear explanation as to why particular approaches had been adopted by reference to the nature of the effects at issue here. And this is an opportune time to respond to the matter that was put by the committee to the school about, well, it was in the context of, you say, for example, that a more detailed mapping of seagrasses should have been completed. And the question in effect is, well, how would have that assisted or benefited our assessment of the environmental effects of the process of the project? Why is that necessary to have been completed beyond the approach that had been adopted, which is at a coarser level, but in our submission, a level that furnishes the committee with appropriate information to assess environmental effects? That question was put to Dr. Edmonds, and in our submission, the answer wasn't persuasive. The schools had another go at it this morning, and when you come to look at that answer, ask yourself, are you convinced by that answer? Are you convinced by the identification of what are said to be differences between the different seagrass species that would give rise to different environmental effects necessary, or do they warrant the mosaic approach of seagrass mapping to have been adopted here? In our submission, the answer is clearly no, they don't warrant a different approach being taken. Quite to the contrary, when one has regard to the relevant tests or thresholds that apply to dredging, or to the relevant assessment having regard to the operational impacts of the project and the incredibly detailed work done within the flumes, the committee should conclude that it has more than adequate information to assess the likely extent of environmental effects, and that any differences in response between different seagrass species, firstly, hasn't been made out in a way that would materially bear upon your assessment, but secondly, simply isn't necessary in order to assess the types of impacts that are likely to arise from this project, be it either through dredging or through operation. That's our response to that matter. The only other thing I wanted to say is that the school, we addressed this at 93, the school advanced criticisms in respect of the provision of what it described as being the most recent simulation report in the context that is as part of this part of its written submission. But we wanted to point out that the school made a request for the provision of the simulation report, not in the context of the marine impact assessment, but in the context of the noise impact assessment. And so what it asked for and what it was provided with is the simulation report referenced within the noise impact assessment. So again, a demonstration of the proponent providing the exact thing that the school requested. And somehow, in the context of its submissions about marine impacts, the school has sought to criticise the proponent for not providing a report in circumstances where it provided exactly the thing that was asked for as it existed in the context of the noise assessment rather than the marine impact assessment. Okay.
Just before you move on to other matters,
Yeah.
assuming that that's what you're about to do,
Yes.
I just thought I should check in to see how everyone's going because we've been going for a little while and we haven't eaten for a little while. How will we track all? Okay. You need a minute. Yeah. Yep. Let's go.
Okay. No, I'm done. Thank you.
What I've had the benefit of doing because of that happening, it's really, I can cut very quickly to some points that'll close us out for the day. One of them was the one that Mr. Cheshire had started on, which is where I had declined earlier, but a couple of examples of why we say the case against us, particularly put by the school, mischaracterised the argument, but also quite a bit unfair to the provision and the cooperation that Viva had offered, and we shouldn't let just stand as criticisms. But if I can do it this quickly, the first argument goes to, or the first one is possibly to go to paragraph 225 and the preceding paragraphs concerning the work of Dr. Yates. And
Is this of our submission?
yeah, of your submission, I beg your pardon, Mr. Financier. Paragraph 22, 24, where this is, we've seen this several times in this submission. It's put that we said something, which we didn't, and then we're criticised for what we did after. So this is a good example. At 224, Viva asserts that Dr. Gard was the first person to raise the question of waves, says it wasn't raised in the EES process, and that further work doesn't blah, blah, blah. Now, it's not correct. What we, in fact, it's the opposite point. The fact that it was raised during the EES in 2022, but not raised as a criticism by the IAC, nor as a requirement by the Minister's directions, enhanced our point about waves, not the other way around. So it's an example of where you mischaracterise what we've put, and then you end up with like 225. With respect, that assertion is incorrect and unfair. Well, the opposite's true. The assertion made by the school about the way we put the case was incorrect and unfair. And there are a number of examples of it. Paragraph 33, the one I said I'd come back to earlier if we had time, I'll do briefly. But paragraph 33, having described direction 1 as a direction, apparently something turns on the wording, but nomenclature, but that doesn't matter. At 33, it said that that we said that the list of items in table 1 defines the scope of the inquiry, and we've said the opposite. Right?
Hold on, where?
Sorry, paragraph 33 of the school submission.
All right.
So it starts by a proposition put on us that we advanced that table 1 circumscribes the task that Viva was to undertake. If I pause there and we say task to undertake to prepare the SES, we'd agree, and defines the scope of inquiry. And of course, we've said that's not the case at all. If something's relevant to the environmental effects, that's in the scope of the inquiry. So you get an analysis, you get an assertion we made, we didn't make. And then 34, we get a straightforward Jack comment. The premise is simply wrong on the proper reading of the document, and you get 20 paragraphs about why we're wrong about something we didn't even say. And so I don't want to go through all of these propositions, but the use of Dr. Yates is, I think, another fair example. If you go to table document 15, the committee is advised by our instructors that we'll have Dr. Yates available if there's any questions on the model, you know, that has been assessed as suitably, no submissions criticising it. And then a witness statement comes in and says, oh, what about you haven't got waves in your model? So we go and get Dr. Yates, put in a witness statement out of courtesy to respond to a submission. And you get attacked for this late report you get from Dr. Yates. You know, like, hang on a minute, it was a response to what we think is a weak point, but raised by submissions where outside the tasks prescribed by the minister, they said, what about waves? And we put in a report to deal with it. And then in that report, poor old Dr. Yates says, oh, as a result of this point, I fished around for you. Here, Jacobs did some work 2 years ago. And then that becomes some kind of a conspiracy theory that somehow the Jacobs report was somehow something how did we rely on that or use it, etc. So there's this pattern of kind of ascertaining or fishing, getting something over or misdescribing what we've said and then attacking Viva for it. And there's some examples of it. We just asked the committee when you're reading through the submission, ask yourself in a way, is it fair how our argument's been characterised before we've been attacked for the way we've dealt with it? They're just some examples, but I want to watch the time. So the next exercise I had to do, oh, by the way, Mr. Chessel referred to the simulation report, classic example. That was to show, because the noise assessment uses tugs to get a 300-metre vessel. And the number of tugs is relevant to the noise assessment that's provided, but it comes back as an attack on what we haven't given Ports Victoria. I mean, it's a construct, not a legitimate, fair criticism of the case or even the broader circumstances. So I just want to go to mitigation measures and wind up as quickly as I can. And I'll ask I wonder if we can just, Ms. Mann, share. We'll start with the mitigation measures. 2 comments only that we need to make. The first concerns the MME05 about the turbidity threshold limits. And it's really probably a drafting consideration we ask you to draw your attention to. My eyes aren't good enough to see it on screen, but what you've got in the outcome now of where the drafting of mitigation measures sits is a reference at MME05 to the measure or the threshold, and the reference to the 12 to 15 NTUs, net turbidity units. But
Try and set that on the screen at the moment.
yeah, I don't think we've got that on the screen at the moment.
Are these the mitigation measures you filed the other day?
Yeah, there they are. You see the 2 bullet points there on screen now. Sorry, Dr. Brisky, you see the 12-hour and the 24, reference to the 15 and the 12. Mm-hmm. And that they might be appropriate, but the point is that there you've got a specified threshold, whereas through the case, if you scroll down to the next mitigation measure, you've got actually a baseline requirement to assess thresholds based on the light monitoring. And it seemed to us that if the attachment of if the thresholds are to be applied after that monitoring or the performance-based model, doesn't sit very neatly with having the prescriptive measure in the previous mitigation measure. Now, whether one's made subject to the other or whether you remove the reference in the first mitigation measure in favour of the assessed measure following the baseline monitoring, you might end up in the same place. But it just seemed to us that there was a legitimate point when I think I can't remember, one of the witnesses or in submission, that you ought not refer to both. And it seems to us the better model is the performance-based outcome sought by that mitigation measure following the monitoring. It's by no means meant to suggest that you wouldn't have a threshold or that it might not be the same number. We don't put that. It's just seemed to us they don't sit very comfortably with each other. So we suggest you remove the threshold limits in the previous mitigation measure in favour of the assessment of limits in that mitigation measure.
Okay, so just to be clear, remove the thresholds in ME05,
Yes.
retain them in ME05A.
Yeah, I think in ME05 you'd say threshold limits following MME05A.
Yeah.
Could you say the lower of or the higher?
Well, I wouldn't want to say because I didn't deal with the evidence that closely, but I'm not sure. I think if it's a performance-based outcome from a year of assessing, I wouldn't suggest you have to put any constraint on it, but you should probably consider all the evidence in making that recommendation. But the main thing is, will it work to have the performance-based modelled outcome and that they should definitely refer to each other. But if it was, I can I just ask that one? If it was
I think my submission is you shouldn't qualify it in that way, because if the preferable way is to determine limits through the detailed baseline study, then if those limits are higher, that is a better outcome or a more appropriate outcome. There's no flaw in my submission you need to safeguard through utilising those figures. So I don't think there is a basis to do that. The only reason I jumped in is because this is relevant to the question the committee asked me also about which of the conditions picked up the 12-month program, and it's MEO5A calls for that monitoring to be conducted commencing 12 months prior to the dredging. So it's the one that ties it to the dredging program. So yeah, sorry,
no, that's fine. I appreciate it.
I'll add to that.
All right. Can I just move on? The other one was seagrass rehabilitation. I got half an answer wrong, or more than half an answer wrong the other day on that question of the translocation or transplanting of seagrass. And there are two places where this is relevant, but in mitigation measure ME20, the day 2 version included the reference to planting seagrass once you've buried the pipe along the alignment. So it's a construction planting exercise. And the update to that mitigation measure included, at the request of DECA regions, the words that are in green on screen, detail of the seagrass rehabilitation program, including but not limited to species to be planted, monitoring for success and actions, if unsuccessful, will be included in the CEMP. So that was clearly construction, and I think I'd said to you it was an operation requirement of decommissioning.
I think it was
requirement.
thought to be a decommissioning requirement.
And I thought I should answer that by also showing, if we put on screen, 411.3 of the incorporated document, which calls up a decommissioning management plan. And it requires details of rehabilitation plans to the condition it was in prior to the commencement of development. And I think just for your, I'm not saying this is, I've got this right or wrong, but when I'd heard DECA regions, I had thought they meant at the decommissioning stage, if the pipe was to be excavated, not just left submerged. And that's why I might be half right. It might be that it applies to both, because if you rip up the pipe in decommissioning, you would also expect a similar technique to be applied as had been applied in construction. I don't take it any further than that, but hopefully that explains, that fleshes out the answer we gave to them.
It half fleshes out the answer, the question from the other day. The question from the other day was really directed around why is seagrass transplantation considered in relation to the seawater intake pipe at whatever stage, construction, decommissioning, whatever, and not in relation to impacts on seagrass from dredging.
Okay, because in the construction of the pipeline, it intersects, transgresses through seagrass.
Yeah.
As the dredging program, as we understand it, is below the contour, where the seagrass is. So the dredging impacts on seagrass are the indirect suggestion of that we just discussed.
Yeah.
And we over 8 weeks. So I think what the mitigation measure is concerned with is that direct interference.
Okay. Understood. Thank you.
The last thing I just wanted to this is a comment that just occurred to me in the discussion that was being had around what conditions might be imposed and then on the noise discussion. And without wanting to get into the direct point, I'd like to just make a comment based on experience in these hearings and a recent experience that I think is reasonably public in the context of the Port of Hastings. And it's watching out in assessing particular applications or particular assessments where one isn't across all the broader implications in overstepping or applying conclusions or requirements that might have unintended implications. And the reason I say that is that for an example like this, you're being asked to assess the environmental effect, the impact of noise. And it's generally against existing, it will be greater or less. And if the information before you satisfies you that it's not going to increase the noise environment, there are good reasons why that is a sufficient conclusion for the purpose of environmental effects assessment, because not every project, not everything assessed at a refinery or anywhere else goes through an environmental effects assessment. There are a whole host of things that you can expect to happen over years, whether it's on the record that they're looking at a solar farm next door, for example. There will be noise and construction noise in other activities around what is a critical piece of infrastructure. And if there's one approval that says, oh, you can't do anything else until something else, what does that mean for other approvals that we know won't increase noise and are important? So the recent example that I think is very public was the wash up after the assessment of the Crib Point FSRU, because it's arguable that some of the commentary, whether it was the minister or otherwise, have gone to the operations of the port when the port's now come to do other things. And whether that was rightly or wrongly the case, I just use it at a very high level, a note of caution that you're asked to assess a particular thing, but you're not responding to every other possible activity or future application or other things that might happen in the same context. So it seemed to me a worthy comment to make at the end, just on that discussion I had earlier, because there can be consequences of a pretty arbitrary requirement to say nothing else until this, when there are all sorts of other things, as you know, that are taking place. Indeed, as we speak, as you know, there is construction going on for other pertinent infrastructure for the refinery. Anyway, I say that I mean that in a very well-intended submission about at a general level, but one that's just when you're in your room together having a chat, worth bearing in mind in my submission that you're not being asked to look at everything, and you can't know or be expected to know all the implications of everything, and that therefore what might seem appropriate in one context needs to be thought about in the context of what other implications it might have. So based on that, if I can just check with my colleagues, can I just say, can take it as a given that we've deliberately not read through the whole report. There are some more technical responses to the construction of language and the like that I'm very happy for you to read later. So unless you have any questions for us at the end of some weeks before Christmas and now, it would be my task just to thank you and all the parties, the school and all the other submitters and those people here for all the timetabling, indulgences and care you've taken and everybody's done in the interest you've shown in our case, and to otherwise close the case on behalf of them. Except. Oh, yeah, quite rightly. Mr. Chester reminds me we do have that outstanding homework for Dr. Brisger. We haven't forgotten. I don't know if we had an update yet because he's back today. No, I've got nothing to update you on. But will we rest on the basis we left it that we'll do it ASAP? I'd suggest it Monday to the end of the week, but if you can do it sooner.
This is
will be
rooms that.
yeah, the mapping of the plots to fit the percentiles on a map rather than in a table. We clear what the job is.
Yes.
Yeah. So we don't need any direction. All we can do is undertake to do it ASAP.
Okay. Any questions? Any final questions? No. Okay. Well, Mr. Fernanzio.
I've just got a couple of things.
Yes.
The directions made by you invite submissions or comments in relation to the drafting of the approval documentation within 5 business days of today, really.
Yes.
That lands us sort of immediately after the long weekend. And what I was going to do was ask whether or not there's any real difficulty with that being extended for a few days after the end of the long weekend in order to facilitate that commentary, or whether or not it made a difference to your assessment. We're intending to respond, but we just might have a bit of difficulty getting it all done by next Tuesday.
Look, it makes no difference to us. It
Well,
would technically extend our reporting deadline by a few days, because our reporting deadline is calculated from the day of the last information that's provided. I don't think this would make any difference to our reporting deadline, but
That would be obviously for a proponent in any major case, the question. It's not the indulgences to parties between that time, but it's the extension of the overall time. It's the critical one. If the chair's comfortable that that won't influence that, we'd have no objection to.
Great, thank you. The second one
we should
was,
just say though,
Yep.
when will you be able to get us your draft and comments?
I'd be happy to do it by Thursday next week.
Okay, no problem.
I don't know, I don't want to, burn the friendship or anything, but you asked our friend in the course of submissions about the origin of that 12-month monitoring program, and you were taken to the ministerial direction. Can I just give you the page numbers of the IAC's report where that comes from? It's PDF 67 and 68. And it's those passages which underpin the difference between, I think, the parties on this side of the argument, which is that the expectation was that that happened before approval rather than after approval and before digging.
Yes, just remind me if that was at PDF 67 and 68.
68.
This one, what is the hard copy?
Oh, sorry, 47 and 48.
So this is the IAC's report number 1.
Correct?
Okay, PDFs 47 and 48.
Correct. The very last thing I just wanted to say was that a number of submissions have been made to you about the complexity of our submissions. Just want to refer you to paragraph 62 of the written opening of our learned friends as to scope. Don't feel a little bit gaslit in this hearing. Have a look at what they've said about scope and then assess whether or not the submissions that have been made to you about the lengths to which we've gone to describe how those matters, those documents should be interpreted, should be approached.
Is that their opening submission?
Written opening submission. Document 65. Bit of gaslighting going.
Does that conclude Mr. Fernandio's reply?
That's all. Thank you. I could go on, but I'm busting for the bathroom.
Well, I'll try to keep my closing comments nice and short then. We've heard lots of detailed evidence in submissions over the course of the last few weeks. We've got a lot of information to review, lots of issues to consider and balance. We need to provide our report to the Minister for Planning within 30 business days, which is 6 weeks at the conclusion of the hearing process. And as I mentioned before, I think the slight extension to GDS on drafting comments won't impact on that deadline. It'll then be up to the Minister to determine whether and when to release the IAC's report publicly. That's generally done when the Minister makes a decision about the matter and releases her assessment of the project under the Environment Effects Act. I just wanted to say that we appreciate the responsiveness of all the parties in providing further information in response to our requests and also to the experts. The testing of evidence through the hearing process has been very informative for us, and I thank the parties for the manner in which they've helped facilitate the exploration of the issues. Thanks to Ken for his technical support and for helping us make sure the submitters were able to present what they wanted to present to us, both visually and orally. I just wanted to do a quick shout out to the PPB project team, Amy Selfaraj, Sarah Vujinovic and Georgia Broderick for providing such professional and timely assistance to both us and to the parties. And last, but by no means least, to all of the submitters, I hope some of them are listening in today, but who've taken the time to come along and present to the IAC. We acknowledge the effort behind your presentations and we really value the significant contribution you've made to the process. So I'm going to formally close the hearing, save for the one bit of outstanding information component and drafting comments. And thank you everyone and good afternoon.
Thank you.